And we are back for the verdict in the Commonwealth versus Kelsey Fitzsimmons. And Bob will be with us any moment, but let's get started. Well, hey, everybody. I am trying to get us live. I don't know why this live stream keeps I'm trying to pull the courtroom up live, but it keeps messing with me. I don't know. We realized in very short order that we should have not ended the live. We should have just kept it going since we're coming right back. If we is that no, is he staying back there? Or is he coming in?
Hello.
There he is. I'm gonna pop out. I just like it like that.
It's
That's
weird.
why I got used to it. I got used to you being above me.
It makes no sense.
I don't know.
Oh, they changed it to 2. Oh. All right, good. I'm jumping on. I didn't even get to finish.
Yeah, I'm gonna eat my soup. We both have some tortilla soup, so
it was idiotic for me to end it. I didn't realize we were 15 minutes away from restarting. So y'all are gonna have to, keep yourselves busy while I eat this delicious bowl of soup.
But I want to eat my delicious bowl of soup. We both have to because it'll get cold.
It'll get so cold. We can't have it.
All right, let's say you change the banner and I'll get myself some water.
We have to have warm soup. Oh, change the banner. Oh, okay. This tells me to change the banner. Well, I missed you guys. That glorious 15. Let's see which one. The closings are over. Okay. There. All right. Okay. I'm just gonna say the verdict. The verdict. Okay. There it is. Okay, will be read at, I don't even know if he's going to read it as much as just say it, but whatever. Semantics, 2 p.m. Eastern Daylight Time. Yes, indeed. Oh, good. The judge can keep you company. Judge, we just found out that they now pushed it to 2.
Oh, okay.
So we're and Ali and I are gonna go backstage and eat our soup.
Okay. Yeah. I'll continue doing what I'm doing. I'm in the middle of something, but I thought
actual work, real work.
Actually.
All right, I'm pulling us all off.
But we're going to leave this on so I can just pop
Yeah,
out.
I'm going to keep you. I'm just going to put you backstage.
Okay. All right. See you then.
See you soon. All right. I'm about to vanish behind the curtain and eat the soup unless you guys want me to.
No, they do not. It's the worst. All right, I'm gonna join you backstage.
Probably just put somebody in some kind of like.
Make sure there's a good banner though.
Oh, I did. I changed it. Okay. You know what? I'm going to get rid of the scrolling. Hold on. I'm going to do not scrolling. Just do a good static one right there. Wait. Oh yeah. All right. Bye. Time for soup.
Wait, babe.
No, bye.
You need to create a new poll.
Bye. It's soup time.
He's going to create a new poll. Babe, create a new poll that says, what will the verdict be? The judge's verdict. Just so you guys know, the Kirkland, um, what is this? Chicken tortilla soup is delightful. I'm sure Bob's working on the poll and eating his soup.
The poll is up. Remember, this is what the judge, what his verdict will be, what you think it will be, not what you think it will be. Different things. Vote.
Montana should be getting ready to use her link because we're almost done our soup.
Yeah, speak for yourself. I have like 3/4 of a bowl left. All right, babe, you got to come back soon. We got Montana backstage. We got Lil Montana backstage ready to go. So, yes, Bob is finishing his It's Montana Lil,
Mon-
and I have half a bowl of soup left. You got impetuous.
I did get impetuous. I was
Yeah,
telling
so I mean, you can
ready.
invite her on while I finish my delicious soup.
I'm going to wait for you. So she's got the full, the full Mata feel. But yeah, it is chicken tortilla soup, not canned soup, but like the pre-made soup in containers at Kirkland, and it's really good. It's really good. And I did eat mine very quickly. So wow, look at all these new members. So a lot of these new members are new members that started on our moment ago stream, the one we decided to end for all of 15 minutes just to be ridiculous and lose the 4,000 people we had and swap it for the 1,000 people we now have. But that's the way we work sometimes over here. We've got Mrs. Bucket. We've got, I think, like the E for koala, like E koala tea. E koala tea. It's very cute. E koala tea. Trial World TV. Welcome. Made of Questions. I know I've seen some comments from Made of Questions even before she became a member, so that's great. AI Miss OG, or is it A Miss OG? AI Miss OG. I don't know, but member for 10 months. Thank you for your continued support. And Kim CNMT, member for 10 months. Thanks for your continued support. Not guilty for Kelsey. Yes. Yes, that would be nice. That would be nice. Let's see. So not a Karn, I think. Karen? No, not a Karen. No, whatever. Sorry, I'm horrible at this. Even if it's 100 degrees, I'd still eat soup. Bob and I went on like a soup only diet in law school. It was really just an excuse to eat the soup at this place that we really loved. It was like the all soup diet, but it was really just, they just had the best soup all day, every day. It was delightful. But I'm always up for a good soup. Deja Vu, 25 months. See? And Deja Vu doesn't have a badge. And so now I realize what Bob's saying. It's not, you can't just throw up a badge because it has to be a cool badge. And since Bob's the king of cool, I honestly can't help. Honestly can't help. I would just make it purple. Here you go, badge. But we definitely need a badge. All Eyes in Delphi says only if it's a soup sandwich situation. Well, Milk, you're not alone. Other people fear the same. I don't know if that's a fear for you or you'd be happy with that verdict situation for you. But I don't think it's a foregone conclusion here. Kyle's asking to see the animal in the tree. That we did that video. We up and done that video. And I think we all decided it was an owl, but then I think we also said that would be the world's largest owl ever. But then I think we heard it again and it was hooting. I'm pretty sure it was an owl. And now the dog is barking, so stand by. While Bob finishes his soup, I get our dog, and Montana Lil preps to be on screen. All right, I let the dog in and I let Bob know I'm ready. I've got to meet this fabulous looking woman sitting behind stage right now, won the wheel. It's Montana Lil.
Hi.
Hey. So is your name Lil? Because I keep wanting to make it like short for little, like Lil.
No, my name is Dee.
Oh, okay, D. So it is like Lil, like short for little.
Right.
So good. There you go, babe. Ha.
I'm here. Hi, Montana Lil. Welcome.
I told
Hi,
you.
Bob.
I was like, "But we've got to hurry up, babe. We have the most adorable guest."
I heard, babe. I was right upstairs eating my soup. Welcome to the show, Montana Lil. We
Thank
love
you.
having you here. We're so happy that you're using your camera so we can see your beautiful face. So,
Aw.
where are you at? What are you thinking?
On Kelsey, I'm thinking not guilty. I have been thinking not guilty, but with this judge and with the testimony, I'm just not sure that the judge is going to go that way.
I know it's scary. It's scary.
Yeah,
It is.
it's a real
I
fear.
mean, it's like I feel more comfortable, and I think that the closings would have been different had there been a jury impaneled. But I
I
think
popped you
that
on, Judge. I hope you were ready.
she wasn't ready. She was doing some yoga. Back,
Deciding if I'm putting a jacket on. I think I
But,
won't.
you know, I'm hopeful. that
Let
the
her say,
judge is
let
going to be able
Montana
to-
Lil say hi to Judge Carol.
Hi, Montana.
Hi, Judge. Oh my goodness. I love you. I love your perspective. I love the work you do. And I'm so appreciative that you're willing to share it with people for, to give people more knowledge from the judge-based opinions, because no other judges really want to, give their full opinions on things. So thank you so much.
Well, thank you for saying that. I really appreciate it. And I'm careful about which ones I do and where I appear. But I think there are just times I have to say something. And even though there's sort of this unspoken rule, for judges, when you're on the bench, you can't really say anything. But when you're off the bench, they kind of expect you to continue to do that. I just can't do that, not when I think something is unfair. So I really appreciate it, because I definitely get pushback from people in the system for speaking out. So, I really appreciate it when people like you say you're learning something from it. So thank you so much for that.
Yeah, and we obviously echo Montana's sentiments.
Hell away from their parents.
It's devastating.
We've been.
It preys on all of your
What's
worst
that?
anxieties as a parent.
Sarah Perkins and husband
You hear that?
Yeah, it was me. Did you
Oh.
hear it? Or
I
Is
don't
it
know.
playing?
Every time I start talking, you do something. to
No,
me.
is it playing in your background, or you could hear it
If
from my
you have.
screen?
Yeah,
Has
we
it
can.
been
I
paused?
heard it.
Is it paused?
Yes.
Okay. Yeah, it was the trial stream. So I don't know what happened. I'm gonna go figure that out. So we're
Wait,
not.
on 10?
Yeah.
Oh, it says I've got it live. Huh.
I don't know what the heck I'm watching.
I don't know.
It says.
Oh wait, per usual, I'm behind time.
Okay.
Oops. Never mind.
I'll just keep
kidding.
an eye on it.
All right. So, but I was just saying, Judge, we have so adored having you here. It's been just amazing. And I'm so happy that you're seeing it through to the end with us, because it's just been a wonderful experience. And I was telling Ali off stream last night how lucky we are. They're like, it has been my entire career of practicing, because most judges I were, had a friendly relationship with were still on the bench. So I really couldn't get into the discussions with them. So your insight and me being able to ask you all the questions I've peppered you with has really been amazing for me, because it's questions that have always wandered around in my mind. So thank you very much.
Yeah, you're welcome. It's a good opportunity for me too. So I appreciate you giving me that opportunity.
100%.
Love to know what it is, Montana Lil, that makes you worry that the judge is going to say guilty. Because I do think there's reason, to believe that. And as I said, it seems like both of the explanations of what happened in that room seem plausible. So curious about what it is that makes you worry.
Well, the judge, when Bradel, as the defense attorney, was trying to turn the judge's attention to the more nuanced aspects of what happened in that room, the judge seemed to be more focused on the law-based aspect of it, and strictly going by the law-based aspect of it, and what facts I guess were presented. She had a weapon and admitted to having a weapon in the room with a police officer. So I mean, the fact that the judge was always pulling Bradel back to more of law-based rather than the nuanced, things that might play better in front of a jury.
Perfect. That's exactly right. I mean, his closing, had all the usual kinds of things that you say to a jury, like this person, he had a plan. He didn't like, or whatever, the kinds of things that you can say to a jury. But, the reason the judge kept doing that is because it's his job to just basically apply what is in those jury instructions by using the evidence that he believes or doesn't believe. And so it's a much more nuanced aspect to beyond a reasonable doubt than it is with a jury. And, when you're only dealing, even though there are multiple elements, like there must be a dangerous weapon. Well, of course, we all know that element has been met. When it boils down to one element, it's really tricky. So I hear what you're saying and why you're worried, because his closing arguments, and, as people were saying earlier, Ali said, why did they bring in the moral thing? I think that would have played better in front of a jury. But, telling a judge, hey, she's a moral person, so when you make your decision about whether there's intent, I want you to look at it from that aspect. But I'm not sure that would play well with a judge, because that's not how I would be looking at it. I might think, yeah, she's a moral person. She's a lovely person, and I like a lot of what she said. And I might be thinking she's been through hell. But those things are all different than what he said, which is, was there some perceptible moment, where she pointed the gun at him?
Your Honor, I've been thinking about that since we got off our live. And I've been worrying about whether I'm looking at it through the lens that I want to be looking at it. And could he not be thinking of the intent that still has to go with that? Is he actually thinking, I only need to decide whether or not she pointed that gun at him for a perceivable amount of time?
Yeah.
And and I just want to say, and I get your point on that, which you made going in. It's like, well, if she literally pointed at him, like in the manner he described, well, then that has the intent is implied through the action. Like the judge can't say, well, she pointed it at him, but she had no intent, despite the fact that she testified she knows when you point a gun at a policeman, they're seeing a threat, so, but it did make me worry. Is he not even thinking about count one? And we went over count one, the jury instructions, and when it goes to immediately threatened a battery, the jury instruction says, to prove the first element, the Commonwealth must prove that the defendant intended to put Noonan in fear of an imminent battery. A battery is touching that is either offensive or likely to cause bodily harm. Goes on to say a person's intent is, and I know you know this, Your Honor, but for the people,
to let people know, right.
A person's intent is their purpose or objective. This requires you make a decision about the defendant's state of mind at the time. You may consider any evidence about the actions or words of the defendant and, to Your Honor's point, all of the surrounding circumstances. Again, not just that little room, and like you've been saying, but all the surrounding circumstances to help determine whether the defendant intended to commit a battery.
Yeah, I agree. I think that's the worry. I think that's what we just talked about here. All of us, all four of us, are kind of asking that same question. Is he just limiting it to, if I find that she pointed that gun at him, then I'm going to find her guilty, because I can't, as far as he's concerned, if she pointed the gun at him, that was the intent. I mean, it's hard for me to say that, because the fact that she might have picked up the gun momentarily,
right,
and while she was taking the gun and putting it to her head, is that enough for him?
I would hope not.
I mean,
oh, I'm sorry. I didn't mean to. I just wanted to quickly say what I'm also concerned about is the judge and how much thought he is giving to Noonan as far as having to make a split-second decision, and the judge's experience with police officers in that type of situation. How much leeway is he giving Noonan for having to make a split-second decision? You know.
Well, yeah, I think the answer to that is he doesn't have to consider that because you know, it's not Noonan who's on trial.
Exactly.
So
Right.
when you consider whether or not under the United States Constitution and under the cases from the Supreme Court, the time that you consider that is when the district attorney is evaluating whether or not Noonan made a reason, whether or not his decision to fire could be considered reasonably objective in the circumstances. Because the Supreme Court says we have to recognize that police make split-second decisions. They also say even if those decisions were wrong, it doesn't mean that the officer should be held accountable through criminal charges. And the reason they say that is because it's easy for us to, you know, take a look back in hindsight. But the Supreme Court says you can't do that. You can't go back and look at it in hindsight. You have to look at it as if you were a cop, you know, because the way they decided is, would any other police officer think it was reasonable for him to fire in those split-second circumstances? He's not expecting a gun to be there. All of a sudden, a gun is there. And whether he misinterpreted, you know, whether it was suicidal or not, the law says it doesn't matter. It only matters if it was objectively reasonable. And when you consider if it's reasonable, you have to allow for the fact that he gets to consider the information he knew going in. And even if they were lies, but the information was, and she was dangerous. So he was exonerated. You know, I've taken the position that it was right based on under the U.S. Constitution. And I think earlier I said that, you know, of course the judge knows that he doesn't have to decide it. He said, I don't have to decide if it was reasonable, because he understands that's the constitutional standard applied elsewhere. I only have to decide on the elements. He said that a lot. So I hope that answers the question, because I appreciate you asking it, because a lot of people are asking me that question.
It was a wonderful, wonderful answer and a wonderful question. And I want to follow it up with Montana. That's one of the things I always worry about with jurors, in terms of, are the jury instructions clear enough so that, because I've seen it in I'm certainly not pointing you out specifically, because I've seen it over and over and over again. And I've been, especially on Twitter, I'm like, Noonan's not on trial. It does, like, for the purposes of figuring out what this judge has to figure out today, Noonan's intent or what he thought matters not. You know, so, but
and it's hard for people to separate, as Bob's noticing. It's hard for even lawyers, but especially laymen, to separate the two out. And I think, like Judge Erskine just pointed out, we have the benefit of this judge saying repeatedly and actually very firmly that I am not considering whether what he did was reasonable or not, which just means to tell us all it doesn't matter. It's not going to weigh against her, and it's not going to weigh in favor of her. Like, it is what's the word? Like the term non-existent, but in, like, I don't know what language they say it in. I don't know.
I'm not there with you, baby. Usually,
like,
I can.
I know. Usually, I can just say something random, and Bob can pull my thought for me. But
I think it's two different things. You know, it's just in the same way as if there was a civil trial going on, you know, for negligence in this case against the police. Let's say she filed it for the way they filed the restraining order. That's a whole different standard about whether they were negligence. It's a civil standard, and it's and the facts are different. And you can't have a judge in a criminal trial considering that, you know, because they're literally two different things. And so, you know, the investigation and the exoneration of Noonan is a completely separate thing. But it's very clear, you know, when you're talking about what the judge said, it's very, very clear that this judge knows that that's the standard, because he used the word reasonable. You know, he could have said justified. He could have said anything. When he said reasonable, it's like he's explaining this. And I explained it yesterday also on Twitter. And as I said earlier, I kind of got a message from Bradel saying, but, you know, there's a Massachusetts law that says, you know, that you can't use deadly force if someone, you know, someone's at risk, and she was at risk. And I said, well, you know, that's true. And I certainly understand your position. I'm just looking at it from the perspective that the Supreme Court says we must look at it, not within the context of this criminal case, which I said that he was doing. I said, I'm looking at it in the context of why they exonerated him. So, you know, it's two different things. But I think, you know, as Bob and Ali have pointed out, a lot of people, you know, on Twitter are posting about him, and you know, in this case, he's the victim.
Right.
You know, here in some.
And here's the thing, I kind
Wait,
of
hold
weigh.
on before you start, babe. I just want to announce we are 100% streaming the verdict as it will be read. They switch it from 1:30 until 2. Both Ali and I have our eyes on the screen. As soon as it comes up, we'll pull it up. I know people get nervous. I know people get anxious. We're keeping an eye on it. As soon as that happens, we will bring it back up. But yes, we are absolutely.
Yes, this is what is presently on NBC Boston 10.
Circulation. Wow.
And on Court TV, it's a black screen. So don't.
It's always a black screen on Court.
Right. So nobody worry. But it's because of what we're all talking about here, and because of how clear the judge made it, that I am not thinking about what he did wrong, and because I think this judge is any kind of sway that you have with him is not pointing to the fact that he is a bald-faced liar, scoundrel, Noonan, you know, a corrupt person that has defrauding you, Your Honor, that I might have focused on the other failures that were obvious. And we talked about this when you hopped off, Judge Erskine. There are those failures that exist. One of them was just in my mind and I lost it. But I talked about before, the first one being when you came in, you didn't secure the weapons right away. That is something that, you know, put them at risk of the shooting, right or wrong, being challenged about did you cause the problem? And two, you say, were they really making safe decisions? Were they really doing everything right? Because if they knew she said the weapons were in the basement, why did they let someone go to the basement before they cleared it? And, you know, three, how did, you know, you could not have been keeping your eyes on her or, the whole time, or she wouldn't have gotten the jump on you. But there was just something else that you pointed out, Judge, that made me think that's other kind of policy violation or mistake that they made. It could have been focused on without it being he's lying about this to the, being the only thing that the defense laid their hat on. But
I think and I understand what Montana Lil is saying here also, which is the closing arguments, didn't seem, they did eventually seem to focus on what was in that room. I mean, the thing that he did right in that was say, she tried to get him out of the room. She tried twice to get him out of the room. She tried a third time to get the other guy out of the room. All of that is when the judge is looking at what happened in the room, I don't know how he could not consider that, because otherwise he's just basing it on the testimony about the gun. But as the prosecutor said, it's scientific. Well, no, it's not scientific until an expert says it's scientific, not because a prosecutor says it. But I don't know how the judge is looking at it. Curious though what you thought of Kelsey's testimony. Did you believe her? Did you believe everything she said? How did you view it?
I did believe her. She came off as very authentic. Her answers, were straight. There was no she came off as very authentic.
Yeah, I felt the same way. I
Yeah.
felt she
Tell the
was-
people where our poll stands right now, babe. And this is a poll of what people think this judge will do, not their own personal opinion.
Okay, so yeah, we see a swing a bit. So the question was, what will the judge's verdict be? And 83% believe not guilty, 17% believe guilty. So we saw a difference between what we think personally and what the judge might do, which is the way I expected it to be, and that's the way that it should be. The one thing that I'm looking forward to, and Judge, I'm sure you'll attest, as attorneys and as observers of this trial, we are going to get some of his rationale as to why he found the way that he found. Whereas with the jury, they come in, they read the verdict, they poll the jury, and then they're gone. So we have no idea. So we're going to get to hear how much or how little is unknown at this point, but we're going to get to hear why the judge landed the way that he lands. So
And when your answer, Your Honor, let the people know why judges have to or usually do that when it's a judge ruling.
Yeah, I did it every time. I mean, could I just say guilty or not guilty? Yes, absolutely. There's no requirement in a bench trial. The requirement in a bench trial is the person's either guilty or not guilty. There are no requirements, not like in a child abuse case where I had to write 100 pages of why I terminated parental rights, because it was going to be appealed. But, first of all, it's important to do it, as I said earlier. In my view, if he finds her not guilty, I think it's important for him to explain that he doesn't believe that he believes Noonan did nothing wrong and that he wasn't on trial. And this is purely based on the instruction and why he interpreted the instruction the way he did. So that's what I would do, because what you have to remember is, he's considered a victim. In my cases, there would be a victim in the room, if it was like a rape case or something like that. And so, you have to be aware that, there are people in the room other than the defendant and the prosecutor. There are victims and there are people whose lives have been impacted by the trial. And so it's just important to explain, because when you don't explain, I think then people you have people who don't trust the judiciary, because there were other trials, particularly in Massachusetts. And, it's sort of the public, loses its faith in whether or not the judiciary can be really fair, and it destroys the public perception of the judiciary. So when you explain, why you decided, and so there's another reason to explain, because if he finds her guilty and he has explained it and he says exactly what he thinks, there's your appeal,
Yep.
because that the only way you can, were not a lot of issues, the issues on closing arguments, they could say they were improper, but what they would say is, some of the things that he said, which, were clearly not in evidence. What they might say about that is that's true. The prosecutor clearly did that. But of course it wasn't prejudicial, because it was a judge trial and a judge knows enough not to consider that. And even in a jury trial, it will say it didn't, the court would say it's not prejudicial. So if it's not reversible error, it doesn't really mean anything. I didn't see anything in this trial that told me that there was reversible error in the way it was handled, that there would be, that where the court would say, we're going to vacate this, except, maybe in a decision, the appeal might be that the judge, made an error because all things were equal and that has to fall in favor of the defense. That to me would be the appeal, depending on how the judge explained it, because you had two very plausible stories. And unless the judge is going to say, well, I have evidence and the reason her story wasn't plausible was because of whatever, the tap and rack or whatever the judge is going to find, then you can appeal on that. But, I think that this is if she's found guilty, this is where the appeal will come from. The appeal will come from which is very different, as you point out, Bob, because in a jury trial, you only know what they're thinking when people interview the jury.
And you're specifically not allowed to consider what a jury considered, even when we do know it, unless it's stuff outside of what happened in the four walls of the evidence admitted. But yeah, very different. And you guys, for those of you out there, when we say, Noonan is the victim. We mean the legal victim as presented in this case. Under the law and the charge that's here, he is recognized as the victim, which is different than who we see to have been victimized by the process, the situation, and all of that. I also see
Yeah,
some
we can
questions.
call him the technical the victim. You
Yeah,
know?
technical.
Technically, he's the victim in the case, because if you're charged with assault or battery, then obviously the person that you're alleged to have assaulted or battered would be considered the victim.
All right, Montana, anything else you want to ask or say before we let you go?
I wore my merch.
All
Oh,
right.
yeah, baby.
Good.
Love it. I love it so much. Well, we adore you. I hate to brag to the judge, but see, Montana Lil is a perfect example of the brilliant, wonderful people that make up our community. So we're so grateful to you, Montana, for hanging with us. We know you could go to all different types of places. So it warms my heart. Thank you.
I love your guys' coverage. I love your realness. You're so real. I love your banter between each other, how you bounce, comments and everything off of each other. The drama-free coverage. I dropped a lot of my subscriptions after the Karen Reed trial because of the extra drama that means nothing to,
Right.
to anything.
We're
And
with you.
Yeah.
So
That was good.
I appreciate everything you do, and you guys make people better jurors in their community. I want to say that too, because of what you explain, how you explain it. You're giving us information to be better community members. So thank you.
Oh, that
All right,
makes me
thank
feel
you.
amazing. Thank you.
Yes, and
Thank
we'll
you
Pleasure
so
to
much.
meet you, Montana.
Great
Thank
to meet
you.
Nice to meet you too.
All right,
I
bye-bye.
love having you.
Hopefully she knows how to leave, baby. Might need to kick her if she doesn't. So a lot of people are commenting that the judge gave preference to police supporters over I can't find the comments, babe, but everyone keeps
Yeah, I
talking
saw
about
it.
I mean, maybe that's indicative of it's about to be not guilty, so let's let the let all the
I'm not going to even speculate as to
yeah.
it.
Yeah, so there are judges in Massachusetts and even in the courthouse where I am, where the police are there to support the police or some kind of member of their community, and the judge will order that they can't wear the uniforms in the courtroom. That happened in a really big case in Massachusetts, and a lot of people were really upset about it. But in that particular case, there was a jury. So, in this case, there's not a jury. Judge is not going to be persuaded by any of that.
Right.
No, not
Right.
at all.
Yeah.
Not at all.
Well, I am anxious. I'm wondering if he's going to be very narrow in what he does say, for all the reasons that Judge Erskine just mentioned about, being interpreted or applied somehow. Well, I mean, only the defendant could appeal. So if it's a defense verdict, then I'm sure he'll say a lot more than he might, if it's not.
Well, let me ask you this, Judge. I have a feeling that he probably had a pretty good idea which way he was going to go on this, but knowing that he had said early on that he was planning on giving some of his rationale as to why he landed the way that he landed, I think that he's probably taken this time to take the opportunity to kind of carefully craft, maybe bullet point fashion. Maybe he drafted it out fully, but what he intends on saying, I think that's probably been what some of this gap has been about.
Yeah, I would draft it out, after the trial on a bench trial. I would get off the bench if it was a criminal, like a delinquency trial or a youthful offender, and draft out what I was going to say, maybe not word for word, but the things I wanted to bring up. The other thing is, the question is, if he finds her guilty, will he sentence her today? Because in Massachusetts, there has to be a sentencing report. Lots of times in youthful offender cases, where I could sentence a juvenile to DYS or to state prison or to a house of correction. Always in a youthful offender case, and it's by law, in my court, that there has to be a sentencing investigation and report. And I would always sort of order the probation officer to do that ahead of time, because if there was a plea, then I would have it. But I wonder if I think, by law, he's going to have to ask for a sentencing report. So I don't know that if she's found guilty that there would be a sentence today, unless he has already asked the probation department to do a sentencing report. But, based on that and based on their guidelines, I would be shocked if she's found guilty and there's any jail time. I would be simply shocked by that.
I feel the same way.
Yeah. It doesn't fit the guidelines.
No,
but in your experience,
she did 100, I think around 100 days time served, on top of that.
Right.
Like my estimation, if he was inclined to give her any kind of time, it would be for what she did in terms of time served, and that would be it. I don't see her, if she is found guilty, I don't see her going back in under any circumstances.
Yeah, I completely agree with that. And actually, in the motion for temporary custody, which requires a change in circumstances, the motion that's going to be heard, giving her at least half custody and visitation. It's interesting that, because they didn't know what the outcome was, they made clear to the judge in the probate court, even if she's convicted of the current criminal charge, that should not, affect, she's unlikely to serve any prison time, and therefore it should not affect any decision regarding custody and visitation. You pointed out earlier that there'll be a guardian ad litem, because they're basically changing sort of that emergency temporary custody order. There was no guardian ad litem in place. It may be that there's already a guardian ad litem in place, or that they assigned it just to one of their family service officers, it's the probation officers for the family court. It could be there. The question is whether or not there would be any orders, because it's likely that they'll say, well, we're going to do a guardian ad litem investigation if that's not already done, which I doubt it is, because, Kelsey's been dealing with this. So it's likely that they're going to appoint a guardian ad litem or have a family court probation officer do the investigation. The question is whether or not they'll make any temporary orders without finding that there's a change in circumstances, which is what they have to, and whether or not they'll make temporary orders, at least for visitation. And there's no reason she can't have joint legal custody. Even they don't even use custody, if they say, okay, he's going to be the primary residence, then the question is what kind of visitation. So, I'm interested in following that. And so we'll see what happens. It's coming up pretty quickly.
Yeah, it'll be interesting. Legally Blonde, it makes a comment. She says, what is the legal distinction between reasonable and justifiable? Now, I'm assuming you're asking that in relation to Noonan, and I can't really speak to that precisely, and maybe Your Honor actually probably can. So, because I was going to talk about it in a different legal sense, but as it relates to what Noonan did, and I know that's not an issue for this trial, but is there a distinction between reasonable and justifiable?
Well, I make that in my recent op-ed piece that, regarding the shooting by the officer of a violent carjacker who's charged with manslaughter. And when the DA in the press conference basically said, that we don't believe that the shooting was justified. Well, he's talking about that under state law. That's is like, was there a justification for his actions? That's different, again, than the constitutional perspective of whether or not, by the Supreme Court standard, whether or not the officer, acted under the objectively reasonable standard. So the constitutional framework frames it as, was it reasonable? And we're going to explain, they say, what we mean by objectively reasonable. That's different than what you see here, which is strictly based on the elements under Massachusetts law. So that's why the words are different.
Good afternoon, we're on
All right,
the
here we go.
Fitzsimmons matter, docket 2025, 77 CR 311. All counsel and the defendant.
Wow.
are present.
Thank you. So before I begin, I'd like to speak to our audience members. I understand that this case has generated a lot of passion and emotion. But you must remember that this is a courtroom and not a sports arena. When I announce my verdict, you must not act out emotionally or visibly or audibly react. So you should leave the courtroom if you believe that you will be unable to maintain your composure. I'd like to start with a few introductory words. Let me say this, this is not in my script. This has been one of the more exhausting, hardest things I've had to do as a judge, as an attorney. And
Do you have it boosted?
So, as the lawyers know, unlike when a judge presides over a jury waive trial in a civil case, there is no requirement that a judge explain their reasons for reaching a verdict after a criminal bench trial. I do so in this case because I think that Ms. Fitzsimmons, Officer Noonan, and all the people involved in the tragic events of June 30, 2025 deserve an explanation. Next, I'd like to take the opportunity to publicly thank and commend the attorneys in this case. They all did an exceptional job presenting the evidence and conducting themselves in an extremely professional and civil manner. And they did so under the public spotlight in an emotionally charged case. I commend you. To the extent that any of the prosecutors and attorneys may be vilified or subjected to public scorn for simply doing their jobs, in this case, I say that any such scorn is unfair, unwarranted, and simply wrong. These prosecutors and attorneys fought hard, but performed their solemn jobs fairly with the utmost civility, and professionalism. They serve as a shining example of our adversarial system in operation. Now, I'd like to publicly acknowledge the crucial and often thankless role that police officers perform, a role that Ms. Fitzsimmons herself, like Officer Noonan, willingly and selflessly performed for the citizens of North Andover. For this, you should be thanked, not disparaged. For those that think that serving as a police officer is easy, or that officers don't care or take pride in their work, I say with more than 3 decades of experience in the criminal justice system that you are naive, misinformed, and sadly mistaken. The work of police officers is especially fraught with peril today because of our exceedingly cynical, polarized atmosphere where our citizenry often believes that there is a conspiracy under or around every corner. I saw no evidence of a conspiracy in this case. What I saw was dedicated public servants like Officer Noonan and his fellow officers doing the best they could under tragic, rapidly evolving promotional circumstances. What I also saw was a young woman, Ms. Fitzsimmons, who was also a dedicated public servant, react to sudden, confusing, and heartbreaking news. Now let me turn to the evidence and the law.
This actually is
Our
good,
system
people.
of justice requires me to decide this case solely on the law and the evidence. So the only things I had considered in reaching my verdict are the 90 exhibits submitted during the trial and the testimony of the 11 witnesses that testified here in open court. While it may be cold and uncaring, our system of justice demands that emotion, sympathy, and concern for the consequences of my decision play no role in my decision. As for the law, in order to prove Ms. Fitzsimmons guilty of the crime of assault by means of a dangerous weapon, the Commonwealth must prove the following three things. We lawyers call these things elements beyond a reasonable doubt. First, that Ms. Simmons committed an assault on Officer Noonan. Second, that Ms. Simmons intended to commit the assault. And third, that the assault was committed by means of a dangerous weapon. The sole issue before me is whether the Commonwealth proved each of these three elements beyond a reasonable doubt. And more specifically, under the circumstances of this case, the narrow issue before me is whether the Commonwealth proved beyond a reasonable doubt that Ms. Fitzsimmons pointed a firearm at Officer Noonan for any perceptible amount of time. What is not before me are the legality of the issuance of the restraining order to Mr. Ali, the reasonableness of the procedure used by the police to serve the restraining order, the legality of Officer Noonan's use of force, and issues regarding custody of Katie. It is not my place to decide these issues or even mention my thoughts on them. I am thankful for this because my role has been hard enough. What has made my job especially difficult in this case is that by and large, I found the testimony of Officer Noonan and Ms. Fitzsimmons to be credible.
That's it,
on
not guilty.
material and relevant points. In my experience, this is unusual and somewhat perplexing. On the one hand, Ms. Fitzsimmons credibly testified that she never pointed a firearm at Officer Noonan. On the other hand, Officer Noonan testified that not only did Ms. Fitzsimmons point a gun at him, that she also pulled the trigger. Both agree that it happened in seconds near a narrow doorway, and the crime scene photos show that the door frame was made narrower by a clothes rack containing police uniforms that was to Officer Noonan's left. The door frame was also made, the door frame was made still narrower when Officer Noonan used it to take cover when he drew his firearm. During the closing argument, the Commonwealth argued that it is scientifically and physically impossible for Ms. Fitzsimmons' story to be true because there was a bullet in the chamber, and she said that Officer Noonan shot her without her ever racking the slide after pulling the trigger. I disagree that the evidence reflected that the only way to chamber a round would have been to pull the slide under those circumstances.
Hey,
However, even if I assume that Ms. Fitzsimmons lied about not wrapping the slide, it does not detract from the adamancy and credibility of her testimony that she never pointed the gun at Officer Noonan, about which he was equally as adamant that she did. Perhaps the Commonwealth could have easily met its burden if the officers had been wearing body cameras. Under these circumstances, I am left with a reasonable doubt.
there you go.
And I am duty bound to find that the Commonwealth has not met its burden to prove that Ms. Fitzsimmons committed an assault by means of a dangerous weapon on Officer Noonan. And my verdict is, and must be, not guilty.
Yes.
With that,
Yes.
I will hand the signed verdict slip.
Well done, Judge. Well done.
Thank you. I feel somewhat vindicated for having analyzed it like that, and actually saying, I feel somewhat vindicated in saying that.
On docket 2025, 77 CR 311, count 001. The court having returned a verdict of not guilty, the court orders it to be discharged of this indictment, and this indictment only, and go thereof without delay. Kelsey Fitzsimmons, as required by statute, I must inform you that the records regarding the charges for which you have been found not guilty will be sealed by the Commissioner of Probation and by the court unless you notify the Commissioner of Probation in writing within 10 days that you do not want those records sealed. To request that those records not be sealed, you may use the request not to seal form posted on the trial court's webpage on mass.gov, or a copy of which I will hand to your counsel. I cannot accept the form here in court. You must submit it to the Commissioner of Probation at the address provided on the form. You understand?
Yes, I do.
Thank you. Court is in recess. Good. All right.
All right. So, I like I said, and with you, I think that we had really analyzed the case really well. That it came down to there were two plausible explanations.
Yep.
And when there are two plausible explanations, I mean, he made clear, I cannot find that they have met their burden beyond a reasonable doubt, because when all things are equal, that's the way it is. How did I know he was going to find her not guilty when he started talking?
Right.
Because he did exactly what I said I would do.
Yep.
I would say, hey, there's no conspiracy here. Police officers have to make decisions in split seconds, and they do so. And I don't find that, Noonan, that Officer Noonan did anything wrong in that split second decision. He went right to the Supreme Court cases that I was talking about to say, there's no conspiracy here. The police are really important. And, I teach police for a living, and I know many of them, and I respect them, and I just have a lot of good to say about them, despite how people feel. But I am, just happy that I could, see it the way I thought the judge should see it.
We loved it. It was wonderful. Your analysis was spot on the whole way.
Yeah.
And obviously it was helpful to Ali and I, because we felt the exact same way that you did. So
Well, let me ask you guys, what did he say? I don't believe the only way is by sliding the slide, or by Kelsey sliding the slide, as far as getting the chamber in there. Which word?
I missed that too. I'm not sure. I do think it was good that he relied on some of the gun evidence, but also disregarded evidence of things that were not. So he even mentioned that. I think that, that he can't just buy a statement by the prosecutor. That
I'm going to find that spot while you guys talk. I'm going to
Yeah,
find that spot.
I think it's been really a pleasure in being with you, because I think, you've asked great questions, and you kind of assessed the case, and kind of saw it the same way I did.
Yeah.
As this morning I said, based on my evaluation of this, whether closing arguments or not, my finding would be not guilty, because you cannot find beyond a reasonable doubt to a moral certainty, which is another reason Brattle might have mentioned the word moral, because it's in the judge's head. It's like, oh, I have to find this by a moral certainty. But I think, the discussion, that we had often about, listen, her testimony was so believable, and she did such a great job that, as a judge, you have to remember, and I have to frankly, think that she definitely made the right decision doing a judge trial, because they're not going to do an instruction to the jury saying, if you find all things equal, and if every explanation is plausible, then you must find in favor. That's not an instruction. It's just there is something about it, maybe in the reasonable doubt instruction. But, from me, the minute she testified, I could not see how she could be found guilty when you have two plausible explanations. And you guys did a great job of putting that out there, over 3 days, how can it be? How can a judge possibly find it beyond a reasonable doubt? But I do love the judge, because I think he explained it. I have to say, as I said this morning, it's exactly how I would have explained it. I would have started out by saying, I want to just say, this is a very public case. I know there's a lot of emotion. And, I understand that there have been, feelings about the police and conspiracies. There's zero evidence of conspiracies or the police acting in bad faith. And I recognize that Officer Noonan had to make a decision in a split second, and he's not saying it's wrong. He did all the right things,
Yes.
and it's just, I don't know, it's just comforting to know that, he evaluated the case just the way a judge should evaluate a case in a bench trial, and making sure that he's recognizing, like I said, and recognizing, like a not guilty in a rape, and, still talking to the victim and explaining, it wasn't a bench trial, but explaining, that there are legal nuances that, bring it about. So
Yeah, Allison keeps pulling my screen off. I fully
No.
intend on showing the press. I
Yes,
understand
yes,
you
I
wanna do it.
understand. We're going to show. I was never not
I
doing
want
it.
to show it in real time.
Yeah, keep an eye on it. It hasn't started
I
yet, but I
am.
want to. So this is the 1 minute in time where he's reciting the facts as he found them to be, and
Yeah.
I double checked what he said about the slide, and that's why I was like, I wish we have Runkle, who is
Yeah.
Ian Runkle, also a lawyer who,
I
yes,
know Ian,
yes, so he knows a lot about firearms, because I didn't know if the guy testified the only way to get it in. So here's that 1 minute of where he's breaking down exactly how he interpreted or decided the facts.
On the one hand, Ms. Fitzsimmons credibly testified that she never pointed a firearm at Officer Noonan. On the other hand, Officer Noonan testified that not only did Ms. Fitzsimmons point a gun at him, that she also pulled the trigger. Both agree that it happened in seconds near a narrow doorway, and the crime scene photos show that the door frame was made narrower by a clothes rack containing police uniforms that was to Officer Noonan's left. The door frame was also made, the door frame was made still narrower when Officer Noonan used it to take cover when he drew his firearm. During the closing argument, the Commonwealth argued that it is scientifically and physically impossible for Ms. Fitzsimmons' story to be true because there was a bullet in the chamber, and she said that Officer Noonan shot her without her ever racking the slide after pulling the trigger. I disagree that the evidence reflected that the only way to chamber a round would have been to pull the slide under those circumstances. However, even if I assume that Ms. Fitzsimmons lied about not racking the slide, it does not detract from the adamancy and credibility of her testimony that she never pointed the gun at Officer Noonan.
This is what we said.
That's what we said it the first time around.
Yeah,
That all right.
Yeah, we said that earlier. We
Right.
just said, look, even if you agree in the closing arguments that she lied, that does not translate to intent to. So good for her. I'm happy for her.
Yeah, it was the right verdict. It was the right verdict, and frankly, it's exactly why I would have gone bench.
I mean, it obviously was the absolute positive right choice, because I think a jury, the best you could have hoped for was a hung. That's what I thought.
I agree. I think, people can be persuaded, by the fact, that she's in a room and a gun and all of that. But I mean, I think the very first day, I think when she waived a jury trial, my tweet was, it was a good decision because it takes the emotion out of it, and juries are swayed by emotion, and he was swayed, strictly by what happened in that room. And, he was kind to the police, and of course, I don't see any conspiracy, but I think we can't drift away from the fact that there were policy violations by the North Andover Police Department by bringing civilians to service of a restraining order. That's like bringing a civilian to serving a warrant. You just don't do it. And I was pretty happy to hear Kelsey say they got it backwards, and she was right. She put it out there. So it's very interesting. But I think, I did a little bit of analysis on another podcast, but not much. It was on very briefly on the Brian Walsh case. I think this is the first one that I've actually sat through a trial, because I told Ali, I'm like, how do you do this? It's exhausting, I couldn't
Did you have fun though? Did you have fun?
Yes, yes. I think, my husband was like, do you think, you would do it again? I said, only for the right case, and something that I feel strongly about. I don't put myself in the frame of, I want to be an analyst, and I want to be on court TV and all of that, because, that's, that's, really not, it's not necessarily my priority. I think someone on Twitter said, "Oh, you're just kind of a has-been that wants to be on the internet and wants." Yeah, I just sort of had to laugh at that, because I turned down so many things, and
you have to know, some people think it's like their job just to troll people and to say stuff. And I'm sure you, just out of like what the average person would have is like implicit respect for you and your role and who you are, that there's so like the average person's going to get it way worse. So I bet you were getting it much less, but yet some people literally consider it their job. But why don't we, and I'll take it off your face after I read what the
hold on, let me say something first.
Okay.
And Judge, to what you were speaking of, the way that I look at it, and I look at it, from the perspective of our channel here, if you don't, as a citizen, if you see no value in hearing from somebody who sat on the bench for decades, I can't help you. I can, to me, it's invaluable. Your thoughts, your analysis is absolutely incredible. And I feel the same way, frankly, about attorneys that are on LawTube that, spend their time trying to educate the public. And I'm so thankful that Montana Lil said exactly what she did. Nothing touched my heart more than saying, what you do here on this channel is you're helping make better jurors out there, because we have an understanding, if we get called for duty, of what things mean, because lay people don't necessarily know the operation of law and how it's supposed to work. They don't understand the nuances. And frankly, for me, the concept of beyond a reasonable doubt, I think, is beyond a lot of jurors, because it's a very slippery definition. We know almost every state in the union has a different definition of what that means, and because it's very hard to define. So
Massachusetts being one of the strongest, thankfully.
Yeah, I mean, I love that moral certainty.
Very strong definition, but yeah, I mean, one of the I mean, people are going to say what they're going to say on X. I mean, I've heard a lot worse inside my courtroom from 15-year-olds, so it doesn't really bother me. I mean, it just is what it is. I mean, I would think 99.9% of at least, the stuff I've read on notifications has been very, very positive. And, I had, lots of people asking me if I was going to weigh in about this, because I had weighed in online about the custody thing and the constitutional issues. And, I kind of, I was happy that you asked, that asked me if I wanted to do it, because I wanted to choose the right forum, because that's really important to me. And, for me, this is a forum that works well because, you're willing to do analysis. I mean, you could just run the trial and not do any analysis until afterwards. But when you do that, when you don't stop it and explain it right then you can lose that perspective that you wanted to make at the time. So I like the forum. I can honestly say, forums that I don't like, Court TV, where they call you the day before, they don't tell you what they're going to ask you, and then they do a segment and you're on for 2 minutes. And I've been a lot on local news and got really great things to say. I've been on NBC 10, I've been on Boston 25, recently on WCVB. Know a lot of reporters, and one of the reporters is on one of those stations is a good friend, but it's a different format. So I think you've put together a really good format here. So I just want to say congratulations on that.
Thank you.
Not only is it a good format, you've got, the personalities and the back and forth, which really, I really did enjoy it, despite it being exhausting, because
Yeah, that's the marital banter portion of
Yeah.
our Ian, I sent the invite. We'd
And-
love to
and-
have you on.
Yeah, Ian, we obviously want to hear your thoughts on all things thus far, but I'm dying to know your opinion on how the rounds get in the chamber and the judge's verdict on that issue and the lawyer's version of it in closing. So if you'd grace us with your presence, Bob sent you a link.
Yeah, I sent the link, Ian. Jump on. Plus I want to know if you're staying with us when you're in Chicago. And I want to ask you directly. I want to put the heat on while you're on the screen with us.
And so I want to put up the unusual. I know we put it up a couple times, but to you, Judge, she says, I want to take this chance to thank this judge so much for finding Harmony's little brother a loving family. Keeps me going, ma'am.
Yeah, thank you so much for that. DCF found Jameson. I finalized the adoption.
Awesome.
He's absolutely adorable. We're very good friends, so I keep in touch with him, and he and his brothers are doing extremely well. The two dads are amazing. He has a life that sadly his sister doesn't. But the one last thing I'll say is he never forgets about Harmony. Every drawing he does in school, he puts a little heart up in the sky with an H in it, to
Aw.
let people know, that he's thinking about Harmony. So I appreciate the comment. Thanks. And hello, Ian. We've texted and sent messages with Ian, but I've actually, this is the first time I've actually meeting him.
And I'm a fan of your commentary. I'm sorry I look scruffy here. It's a
Look
work at home
beautiful,
day. So
Ian. Don't be ridiculous.
I just was like, I'd better get on rather than shave and then get on. But
And of course, I've got to leave you guys because I've got Zoom court, but I want to hear what Ian says before I'm going to be 5 minutes late.
so yeah, I'm a huge fan. So it is lovely to finally meet you. It's on a proper call here. So yeah. I actually predicted yesterday that this was the likely way that this verdict would go because judges don't like burning police officers.
Yep.
And, for anybody, there's potential collateral consequences if a judge says something like, I find this person was not credible. Or if they go even further, I find so-and-so intentionally lied to this court. But if you're a lawyer or a police officer, those things have permanent career consequences.
Yes.
If the judge had said, I find Officer Noonan intentionally lied about what happened,
Yep.
Noonan's done. You can't, you can't send him
Right.
out anywhere because every court proceeding after this will be. So do you remember the Fitzsimmons trial?
Yep. He's dirtied
And-
up.
Yeah, it's just fatal. So judges really hate doing that. But I was watching this trial and I was going, it's a very difficult path to conviction here. So the most likely thing is the judge isn't going to want to burn Noonan because he's a police officer and isn't going to want to burn Fitzsimmons either because she's also a police officer. So if he was going to convict, the ruling I would have expected would have been something like, I find that Officer Fitzsimmons's memory was not correct based on the circumstances. But I mean, at that point, she's done if she gets the conviction. But I didn't really see a path to conviction on the evidence as it came out. So what I was saying is you're likely to see something where either the judge says, I find everyone to be credible, or else just we have conflicting testimony. I don't know what to make of it. And I must, it leaves me with a reasonable doubt without specifically commenting on,
Right.
The
credibility.
of anybody. Right. So, but you've got to
Yeah,
tell
we
us.
felt the
So
same
we replayed back what the judge said in closing about the slide. And I'll tell you, I was shocked. I was like, during the closing, when the prosecutor said the only way to get a chamber around in that chamber is to pull the slide. And I was like, is that true? I didn't know that. I'm like, where's Ian? So he says that. And then the judge says, I find in contradiction to what the prosecution argued in closing, I do not find the only way to get a chamber into the chamber is that the slide needed to be pulled. What is accurate?
I actually thought that the prosecution and the expert I actually thought had pretty decent knowledge, but the prosecution failed to properly go through things in terms of getting to where they needed to be. So there was a few things I would have liked to see excluded. For instance, they have this cartridge. What testing did they do on the cartridge that was removed? Was it cycled through the gun? First of all, was it, I didn't, and maybe it's just memory. I didn't recall them saying anything about like any examination of it. For instance, was there a primer strike on it? Was there a light
Well, it said
primer
something
strike
about
on
a
it?
head, but I don't know what that means. That there was something on the heads of something that might be something different.
So that's the head stamp, and the head
Okay.
stamp is printed text that appears on the cartridge. YouTube, from what I understand, does not ding you for showing a cartridge. So if you are amenable to it, I can show a cartridge. If
Sure.
you're not, then I won't.
No, we
But,
know that you know because you do it on your channel. So go for it.
I mean, YouTube sometimes is a little, whatever. So I've got multiple cartridges here. I'm
They
going to try to
shut
find them.
down some people's lives because the prosecutor was using the firearm in the
Yeah,
courtroom.
it's AI, and it dinged me at one point for an airsoft.
All right, guys, I have
so
to get on this
got it.
Zoom court. I'm going to be listening until the judge calls me, but
So I don't know if you can see that. I don't know if I can make it focus properly, but you can see a little bit of text on the bottom there.
Right.
And what this one says, this particular one, is FHM and then 9mm Luger. So what that tells you is the 9mm Luger it's the caliber, right? So that's important if you want to ever put this into a firearm, because some calibers can look very similar. And they can look very similar. There's a few calibers that if you swap them in, you are going to like have a very bad day, even though they might look superficially similar. But the FHM is the manufacturer. So in this case, it's FH munition. So different head stamps have different text, and you can't necessarily rely on the head stamp either, because for instance, after I take these and use them at the range, I could then reload them myself, and then it says FH munition, but it was actually manufactured by Runkle. So, but that gives you some information. But the question I had, and I, it's tough to go back and try to find something, and see if it's not there. But in the center there, that little disc, that little central bit is the primer. And the cartridge itself is composed of several components. You've got the bullet, you've got the case, you've got the powder, and you've got the primer. The powder is what actually creates the gas that gives the bullet its momentum, its motive energy. But the powder itself is relatively insensitive. You can take the powder, for instance, and smash it with a hammer, and it's not going to do much. So it needs something to set it off. And the primer is quite a bit more sensitive, but it doesn't have the necessary characteristics to propel the so what it is the primer is a little sort of metal cap made of very weak metal that contains a very sensitive initiator. And so it hits the primer, the explosive in the primer then sets off the powder, and that sends things going. But one method of failure that you can have is you can have a firing pin that fails to properly hit the fails to properly hit the primer hard enough.
Right.
So, for example, if you had a light strike, and so I do like 3-gun competitions, and sometimes you draw, you fire, and nothing happens. And you're like, oh, bad. And then you do the tap, rack, bang, and you eject that cartridge and another one comes in. And then later you're trying to figure out, because that cost you like 3-4 seconds just doing that one tap, rack, bang, which is also part of why I found the 3.5 to 4 seconds for 2 tap, rack cycles for, I don't believe Kelsey Fitzsimmons is John Wick. I don't. And, maybe the prosecution could have gotten me there. Maybe they could have brought in evidence of like, look, she competes in these matches. She's really good, but I didn't hear it. But if, you pick that up so that you're trying to figure out what happened, because you don't want it to happen again the next stage, the next match. And if you see a light primer strike, you know that your firing pin is not impacting that hard enough in order to properly get it to fire. So that's a source of unreliability. So, for example, if we had seen the cartridge with a light primer strike, that would have told me a very different story. It would have said she had a cartridge in the chamber, held it up, and basically was one of the luckiest human beings on the planet at that particular moment because it just didn't strike. And then at that point, you've got a cartridge that's in the firearm that is, whatever. The other thing that
required another person to rack it. That
doesn't require another person to rack it in the slightest. The other thing that is possible is officer manipulation, because we had officers there. And, I know people leap to conspiracy on this one. It may or may not have been like, you could have Noonan go in and look at the gun, go, oh, that was not chambered, and then just chamber around and be like, all right, we're good here.
Right.
But you could also have, this also comes up with people who, for instance, they're doing the steps to unload the gun. They might do them in the wrong order. They check, they chamber around, they go, oh, right, I was supposed to take the magazine out first, and then they eject around. It's a really common thing. You'll see people who have used firearms all the time. They go over to like an unloading station, and the first step of the unloading should be to remove the magazine and then clear the chamber. But all the time you see people pull back the slide. And this can just be, if you're wondering if the gun is loaded, they pick up the gun and it's like, did the gun fire? No, it didn't. Pull back the slide to be like, why didn't it fire? And you see empty chamber, you see rounds in the magazine, you let it go. Now it's chambered around. Now you go, okay, now we're going to unload it. So all of this is entirely possible. And it is one of the things I thought was really interesting was that on direct versus cross with Noonan, you see two different stories come out. Because on direct, Noonan says she had the gun, she, tap, rack, fire, tap, rack, fire. The problem is that puts a cartridge on the floor. Right. And then later on cross, when he starts getting pressed about this, he comes up with she slipped on the first one. And it seemed to me that it was after he starts realizing that problem as defense gets there, he's like, well, she slipped. And I wanted to see Bradel, and Bradel did a great job. I nitpick because that's how lawyers are after the fact. I nitpick myself.
We nitpicked as well.
I walked out of the Supreme Court having won at the Supreme Court of Canada, and the only thing I could think for like the next 12 hours was all of the things I wish I'd said, notwithstanding the fact that So that's just how we roll. But
hazard of the trade, man.
Yeah, absolutely. Did lots of appeals and the same thing. But it's interesting because I didn't really pick that up about the casing, and that's really, just interesting to me. Because as you said, it would have been on the floor, and you could see that because you understand all this stuff about firearms. As a judge, I probably wouldn't have picked it up because I just wouldn't know that what he said was wrong, because what you're saying is then he sort of changed his testimony. We knew he kind of changed his testimony, so we knew there was something wrong, but it's very interesting to hear exactly.
Yeah, I'm glad you mentioned that, because that's exactly right, Ian. There had that been racked again, there would have been a cartridge on the ground.
This is why I sometimes do like firearm consulting for other lawyers, because had Bradel come to me ahead of time and been like, okay, I would have said, oh, all right,
yeah,
I want a firearm expert on your side, and I want and I would have gone into some questions like when he comes up the second time with the slip, I would have been like, you have to hit that. You said that now after I started getting into it. Why wasn't that in your testimony on direct? And then you're a firearm expert. Like, you're this really, you're hardcore. You defend nuclear sites. You're saying that on direct examination, you didn't realize that the slip wasn't a key factor? How about that? And really tease that out and put it there in front of the judge. But we get, and then the other thing is that if you partially rack a slide, what you often do is you create a double feed situation.
Yeah.
because you fail to properly remove the fire, like the cartridge. It fails to eject, and then instead you're just, getting it to just jam up. And it's like,
Yep.
well, so I mean, what he said is possible, but it doesn't feel like the most likely. And just, things like having an expert to say, okay, how long does it take to do a tap rack? Because I tried to do it. I'm not like world class. I'm not bringing home any trophies. You don't see any awards for shooting on the back wall here. But I've shot before, and I can outshoot most police officers that I've encountered. Certainly, if they're not otherwise interested in firearms. And I couldn't do the tap rack in the 4 seconds. I got it just under. And that is in a scenario where I'm starting the timer, like looking at the clock, going, okay, and go. But this is a situation where she's not going and go. This is a situation where you get the sudden surprise, where you pull the trigger and you're like, and the first delay in that is, what just happened? Something happened that wasn't supposed to happen. And then after that, so you've got like a second or two of processing, and then you go tap, rack, bang, and then you got to process again. I'm just like, I don't think that's, and I mean, maybe his 4-second timeline is not correct, but I just don't see it. It's also quite difficult to do this thing and simultaneously maneuver. So you'll watch competitions and somebody gets a mechanical failure, and usually when they have a mechanical failure that they're trying to clear, they stop moving or they walk slowly as they're trying to clear it, because it's, it's difficult to eat and chew gum.
Yeah.
Or, sorry, walk and chew gum here, right? And so when you're trying to solve that problem, he's saying that she is doing that while simultaneously like bobbing and weaving. And I'm going, maybe. Now, if I was the prosecution, on the flip side of that, when they showed that gun in the box that has the Spartan logo and the Molen Labe on it, I would have been like, so you like guns, you like shooting, you've got some proficiency. I would have gone at Kelsey like that,
Yeah.
and just,
Yeah.
I thought the prosecution's cross was
Awful.
awful.
Yeah, I think, I also posted about that, saying, it was incredibly weak, and he just left information out there that he never attacked. I guess, what now is he wasn't doing a lot in terms of cross, because he already had his position, which is the one you're talking about, that he was going to concentrate, on the firearms, and I will say that a lot of that, in his conversation about that, or in his closing, would have been really confusing for a jury. And I will say it's confusing, it's confusing for me. I mean, I've handled guns before. I was telling them the story in my first firearms case, how I sent the firearm and the bullets and the magazine into the jury room, and then sent to
That could have been bad.
All right, let's take a listen to this presser. What do you guys think?
Yeah.
See what Bradle has to say, and more importantly, Kelsey.
Attorney, Mr. Bradle. It's just another day at the office today. Just want to say that we want to thank so many people. We want to thank Kelsey and her family for having faith in us. We, meaning Martha and I, want to thank so many people that Kelsey and her family had faith in us. And, we had a very tough playing field for a long time. And we also want to thank Judge Karp, who did a great job and was a gentleman and treated us fairly and with justice. And that's all we ever asked for. And we finally got it. So we're relieved. And, but other than thanking everybody, I just want to hand it over to Martha, and she's going to have some words for everybody first.
Yeah, so thanks, Tim. This is not only the right result, it's a righteous result today. It's been a long odyssey for those of you who followed this. And we started off in this case, understanding, as we all do, and as the judge said, policing is a tough job. Being a mom is a tough job. And on June 30th, Kelsey had to do both. She's trying to be a mom. She's trying to get back to work. And then her world fell apart. And unfortunately on that day, as she said to the judge, and you heard in court, she had to deal with all that. And unfortunately, what happened in that bedroom started a chain of events with a narrative that they never diverged from. They never asked her about it. They rushed to judgment. And that case took on a life of its own, which unfortunately interfered with her life for an unnecessary and difficult time. I think Tim and I have known from the beginning that that wasn't fair, that the charges probably weren't fair, and that we were going to deal with the system and we were going to take this to trial. And as Kelsey has said, without fail, she just wanted the truth to come out. She was able to do that when she testified in this case. And again, we're grateful for the judge's work. We're happy with this decision. And it's the right decision, as we said. She was always innocent until proven guilty. The Commonwealth did not meet their burden of proof, and she is innocent today.
Kelsey, what was it like to hear that word, not guilty? To hear the judge say not guilty this afternoon? You sat there, you know, you were on the stand yesterday telling your story. Share with us what that was like.
So I got shot. I went to jail for 103 days. I haven't seen my son. I had to sell my home that I worked very hard for. So this is my first breath of fresh air, and I feel like I can breathe again. However, my fight is not over. I have a son that I need to reunite with, and that's where we are right now.
Can you talk to us about Keenan, what's next for you, and how this verdict might help you reconnect with him?
I won't get into that, but I will say I am really excited to see my son again.
Do you have any plans to hire a personal injury attorney or have a personal injury attorney representing you?
I will also not get into that, but
yeah, today we're celebrating this verdict.
Yeah,
and that's
I'm
what we're
focusing on
focused
today.
One day at a time.
And I also would just like to thank everybody who stood outside each and every day, supported me, believed me before I got to tell my story, because it wasn't 9 months later until I got to tell the truth. And that was a long 9 months. And through those 9 months, you guys knew the truth. You guys believed in me, and thank you for that.
Kelsey, what's the message? Kelsey, what's the message to others that are in a position like yours after what happened today with the not guilty verdict? What would you tell other people?
Don't stop fighting for what's right. And when you know you didn't do something wrong, keep fighting for that.
Kelsey, do you want to be a police officer again?
I won't comment on that either. I don't know what my career goals are at the moment.
What have the last 9 months been like for you as a person, as a mother, as a defendant?
There's not a word. If you want an image of it, picture me on a mat in a jail cell crying for my son day after day after day after day. There's not a word for that, but that is what happened to me.
Kelsey, do you feel like you're owed something now, considering that you've been found not guilty? All of this stuff has happened to you.
I'm going to leave that one to you.
Leave that one to the lawyers, sir.
Hey, Kelsey, the judge was not exactly speedy in getting to the ultimate decision. How painful was that to sit there and just wait for what was going to happen?
I mean, it's okay. He had to go through all the evidence, and there was a lot. So
we thought he was pretty quick, actually.
Yeah.
And we obviously, with a good judge, didn't have the issue with the jury. He told us when he was going to decide. We knew he was going to write his decision, which was helpful, and he told that in public. So we had this hybrid trial with the judge who was both the judge and the jury, and he was forthcoming throughout the trial, transparent, and told us he was going to tell us why the decision, which of course we would not have gotten with the jury verdict. So it's helpful to have that.
Kelsey, you talked about how this is a just verdict, in your opinion. Were you surprised these charges were brought in the first place, and why do you think they were?
So I'm just going to repeat what I said earlier to that question. A set of things got set into a motion on June 30th that then followed a narrative starting that night in that room that never really got challenged, that never really got investigated with any investigation of her, that never got tested in any way. But the presumption was that she was a defendant in this case. And so that's unfortunate because she couldn't talk for a while. She's being held for a while. She never got a chance really to tell her story. Ordinarily, the system shouldn't work that way, but both Attorney Bradel and I have been on both sides of the system. We know how it works, and sometimes when it doesn't work well and it works slowly, that's unfortunately what happened in this case. And we fought every way with Kelsey to make sure that justice was done. It took longer than it should have, we think. It was more painful than it should have been, but look, we got the right result today, and we are happy with that.
Kelsey, what's the next thing you want to do now that you're not guilty?
Guys, hold on. Let's give these guys over here a
Starting
chance.
today, all of your bail restrictions are lifted, and you said you can breathe again, but there's a lot of changes that are going to take place today. You have a lot more freedom than you had. How do you plan to start that journey of freedom?
I want to go for a walk with my dog. I can't wait to take him for a run. I haven't been able to do that, but that's our thing, is going for a run. So,
And don't forget, she couldn't do that.
Right.
She had to sit in her house. That was her best case scenario, that she was a prisoner in her own home. And then her worst case scenario at the outset of this case, and like Martha said, this was such a bumpy road, a long bumpy road that never should have happened. And, you know, she had to spend time in prison. As a former police officer and corrections officer, she gets sent to jail. Someone with no criminal record, someone who shows up to court, has a wonderful history in this county, and sent to jail. To me, it's unprecedented. It terrorized her, and it's a horrendous, awful thing that happened. This case started out as a circus, and we are so grateful to end up in Lawrence in front of Judge Karp, who, like I said, is an absolute gentleman, a consummate jurist, and he treated everyone in that room with respect, with humanity, with kindness, and we were very appreciative for it.
Do you have a message to your former colleague?
No.
What do you make of the judge saying he credited both Kelsey's testimony and the testimony of Officer Noonan, who called it confusing?
Well, Charlie, you know, he's the fact finder. He's got to make the sausage in the back room. You know, he's got to think about everything, and you know, it's a tough job for any fact finder in any case, really. But I mean, you know, Kelsey has said to you guys every time we're out here, I can't wait to get to the truth. I can't wait for the truth to come out. And finally, she got her chance, and she told the truth, and she put herself out there. The one person in the whole room that didn't have to testify. She's the one that got up there, put herself out there, and told the truth. And the judge, I think, treated her wonderfully and was very humane and kind, and listened attentively to not only her, but to everybody in the case. And we're grateful for that.
And I'll just add two things to that. First of all, people can believe they're telling the truth when they're mistaken, so they can appear to be credible but be wrong. And when a defendant like this is credible, I think, as Tim said in his opening and his closing, that creates reasonable doubt. And so that's the standard. The Commonwealth always has the burden beyond a reasonable doubt. We didn't know that one thing we weren't going to get was a hung jury here. So.
Joe, did you have a question? You okay?
Attorney Bradel, but it's okay. How are you feeling, Kelsey? I feel good. I feel relieved. I was eager to do this, and I said from day one, the truth will come out, and it did.
Anybody
Maybe
else?
if this is doubling up, but you testified that 2 weeks is an eternity for any law. The judge seems, and even the prosecutor seems to connect with that. 9 months doesn't.
It's not a word. There's not a word. It's the most devastating thing that you can do to a new mom. And hopefully changes will be made where a new mom or anyone will never have to go through something like this.
We've talked about that, and we're going to talk about that with legislators. What kind of a system is it that somebody can walk into court, fill out a piece of paper, and in 15 minutes, take someone's baby away, take a mom of a newborn's baby away? It's just an incredible thing, and it shouldn't happen. And we're going to work on some reforms of that statute.
Tim, how much impact do you think it had that the complainant had connections, friends within the law enforcement community? So maybe you can't be just anybody coming and filling out a form.
To be determined, Michael. To be determined. We have some other investigations to work on, and we're going to leave no stone unturned, and we're going to find out exactly how and why this happened, who's responsible, and we're not stopping here. The things that happened to Kelsey, we have, with respect to her home being broken into, we've reported that to the FBI, and I've had it with Essex County, and there are other avenues to pursue, and we're pursuing them. And we're in touch with the FBI on all sorts of federal crimes that were committed, and we're in the process of dealing with it there. That's one example of other avenues that we're taking here. We're not sitting here at Essex County's beck and call. We know where to go, and we know who to talk to, and we are doing that. Anybody else?
Oh, great.
Thank you. Thank you, everybody.
Thanks, everybody.
Thank you. Thank you so much.
Listening to Kelsey Fitzsimmons and her legal team. As you can see, she is outside Essex Superior Court in Lawrence.
All right. Well, there you go.
Yeah, I think, they did a great job. As you know, all week long, I've been talking about the other side of this, which is, what they did to get custody through an ex parte temporary restraining order. We talked about that this morning, where I said, first of all, of course, she was completely mistreated in the revocation hearing. It was just an abomination. I spoke quite a while about that on another podcast about what they did and how they mistreated her.
Yeah.
And I'm very happy to know that they're going to move in another direction. And what did I say this morning? I said, there's a problem with Essex County. And that's exactly what I said. So I was happy to hear that Attorney Bradel said that, because I sort of went off on that tangent this morning saying I have a real issue with what's going on in Essex County, and just not only the way she was treated and the way they moved judges around and the way they mooted they actually ended up mooting the recusal motion because it was so damaging, and just the cases that I've been talking about, the death of Harmony Montgomery because in Essex they turned custody over to a violent father, and now the open case where they're sending a 5-year-old to Guatemala with a man who has open warrants in the U.S. I mean, this is all happening in Essex County, and I think what he's referring to is we're going to look at how this happened, and that means looking at how people are getting custody in a way that shouldn't be. He's talking about legislation. I have legislation filed for an oversight committee about stuff like that called the Harmony Commission, to really take a look at the rules. And that's making some headway with one of the senators that I'm working with. So I'm happy to hear him. And as I told him yesterday when he responded to me on X, I said she was, treated very badly, and I'll be there, to support her in any change in that system, and I'll let him know that again. So,
yeah, and that's a challenging aspect of domestic violence laws and statutes, and in particular TROs or restraining orders, whatever you call them in your jurisdiction. Here we call them orders of protection, but that, and I talk about it all the time on this channel. The real legislative intent was to empower women to get out of these horrific, violent, and abusive relationships, whereas they had no avenue to do so prior to, where you kind of need that ability to do it ex parte, because the fear being, if I have to serve my counterpart with notice that I'm going in to have this done, I'm literally afraid they're going to kill me in the interim. So, I mean, you kind of need that aspect of being able to go in ex parte, but when you have that aspect of custody of a child involved, and I don't know what the answer is, but there's got to be an answer in there somewhere.
Yeah, I mean, I think part of the answer is they did nothing to, even though it was an emergency ex parte motion, and they're saying, hey, she might kill the baby, so I can see why the judge did it. And then, of course, well, this is for 14 days. I mean, to me, that's too much. In my court, which is, in the same group and in the same courthouse, as I said earlier, you get 72 hours and then come in and tell me why this is the truth, but I've been on, as I think people know, the one podcast that I did was really about just being so angry that a judge in the Superior Court, just somehow has the authority to say you can't see your child, and then to revoke her release on a sua sponte motion of her own. So it's just awful.
That made me so mad that, and especially when you hear the audio, because what I heard in that was a judge who had very much kind of lost the judicial mindset, and basically seemed to be angry because Bradel had the audacity to compare this to torture. You could just hear that, the little pop as, the rivet sort of gave way in the thinking there. And she was just mad. And I'm going, at the end of the day, though, you're talking about somebody who's been shot. And it seems to me that it would have been really easy to say, okay, Mr. Bradel, you know what? I think that the alcohol testing is required. And I mean, I don't personally, but if the judge did, because there wasn't any suggestion that alcohol was involved in this. But if the judge thought that, just say, okay, I don't have concrete proposals, but I need you to come back. We're going to set this back in 72 hours. I want you to tell me, can we do blood draws? Can we do any of this? Can you make this happen? Because I'm willing to consider it, but we need the alcohol testing. It would have been a really easy resolution. And, you just say, okay, well, this is workable. She'll have to, go in and, pee in a cup, or she'll have to go in and give blood, or whatever it is.
They said that, Ian. They said, why don't you why not do your analysis? And, the judge just wasn't having it, because what had happened is, for whatever reason, I mean, first of all, she wasn't supposed to be the judge. She just walked into that courtroom and took someone else's place. And secondly, she went to see the probation officer the day before, trying to get him to say that they should revoke her release. Then when the probation officer wouldn't say it in the hearing, she reported him to, the Commission of Probation, and then he had to hire a lawyer. So I would not be surprised if she has, I would not be surprised if lawyers have not reported her to the Commission on Judicial Conduct, because I think when they listen to that hearing, like you say, it just makes you so angry. Everything was so wrong about it. And then to say, well, where's your evidence? Well, we're just in here on a motion to modify that, by magic, suddenly, poof, magic, it's now a revocation hearing. And she wasn't even right on the law, in terms of hearsay. So
that whole hearing was unbelievable. I had never, I mean, they weren't even right. They weren't there on a revocation hearing. And when she was just flame throwing the probation officer, when he's flat out telling her that I would not in any way, shape, or form be reporting this as non-compliance. She was struggling to get it done, but she was getting it done. And if she's a little bit late, you, judge, would never catch wind of it, because it would never be reported that way. And she was just, I had never seen anything like it. And I've been in front of plenty of hot judges that aren't happy with me on various things. And I've never seen them, like Ian said, just kind of lose the plot.
Yep.
They lost that ability to be a jurist. And
I agree with Ian that she was angry, and her temperament and demeanor were out of control, and definitely, in my view, actionable. And as I said all along, because I've been in that system, if anyone thinks that they weren't going to make sure that recusal motion was never heard, I mean, if anyone thinks otherwise, because I'm going to tell you, I've been in that system, and I know how they intervene when the public starts, when things go public like that. And, aside from the fact that the person who assigns judges to courtroom in the Superior Court's the regional administrative justice in that area in Essex, and all of a sudden it comes from the Chief Justice of the Superior Court for the whole state to say, oh, by the way, she's sentenced, she's scheduled to be in another court. And just before trial, even though all the pretrial motions have been done except the last one, oh, we're going to move her out and put another judge. If anybody thinks that happened by accident or that she was actually scheduled there, I mean, maybe it's true. I'm just of the position that I don't believe it, because a Chief Justice doesn't release a statement, saying this is moot. There's something wrong. I think they knew Judge Karp was the right judge for this case, which is good, whether he was scheduled or not. But, it just doesn't work that way. Like I couldn't, like, even in my court, where I was the first justice and I scheduled the judges in courtrooms or in sessions, out, like you have Lawrence and Salem, I had Worcester, Fitchburg, Dudley, or whatever. I did the schedule for the judges. I don't think in 22 years that I was on the bench that the Chief Justice just picked up the phone and called me and said, oh, by the way, I want you to schedule like Judge Smith or whatever the name would be, making up names, but I want you to schedule that judge outside. It just doesn't work like that. And so, people look at it, I think Ian's right to look, you're both right to look at it, like there's something wrong. I can tell you there's something wrong because I was in there and I know how it works and I know how judges get scheduled. In the recusal motion, I'm sure you saw it, Ian, where they said this judge inserted herself into that hearing, even though she was scheduled in a civil session. And they questioned what, she lived, I think they wrote that she lived in North Andover also. So, they said that this judge had an interest in this case, right from the beginning. So yeah, it's just, I've never heard anything in all my time as a judge or a lawyer that was, so unfair and unjust and seemed like there was a plan. But
I mean, if it was up to me, if I was the Chief Justice or whatever, I would not be saying, okay, we're just going to end the recusal motion. I'd be saying, okay, I'm taking over this recusal motion, and Judge, you better make some time in your calendar because you're coming in and you're going to be put under oath, and you get to be cross-examined about how you came to be deciding that you are going to hear this, whether or not you have connections to this, and defense is going to get to cross-examine you until they feel like they're done, because everything here has such tremendous stink on it that you either need to get out here and clear the air and explain all of this such that the public can have confidence in the system, or you need to get out here and the defense is going to burn your house down, metaphorically speaking, until there is just ashes and you're done. Because if she inserted herself based on, and I don't know, we never know because of this, so all we have is speculation. But if she inserted herself on the basis of some personal connection or some personal sympathy towards one side or the other, and, we don't know, but it certainly feels, smells, all of these things, then we want to, know that. We want to, the public having confidence in the system isn't just a matter of, oh, well, we get to the right verdict sometimes. It's also a matter of, how do we get to the verdicts, and can we trust them? And does the court, because everything goes wrong, right? Every system goes wrong. You're going to have bad actors in policing. You're going to have bad actors in lawyering. There's, I've covered some lawyers who've gotten disbarred. But the thing that matters is, can we actually go back and check this and correct this when it comes up? So
yeah, I agree completely. And when he said today, oh, we've got a number of avenues we're going to go down, to me that I believe that they're probably going to file a complaint against the judge for all the reasons in the recusal motion through the Judicial Conduct Commission. I don't know that for sure, but they certainly have hinted, as Martha Coakley said, that the way she was treated all along was unfair. I mean, here you have Martha Coakley, the former Attorney General of Massachusetts. Met her a few times, was on a panel with her. Have so much admiration for her. She's such a brilliant, well-spoken woman. And to hear those words today, made me feel good about the fact that they're going to do the right thing for Kelsey and this baby. And make no mistake about, you guys asked earlier, they asked earlier about a Section 1983 claim. And, the very first element of a successful 1983 claim is, of course, that the person be found not guilty. So she's already met the first element for a Section 1983 claim. Then the second element, did it happen under the color of law? Well, of course it did, because it involved the police. Will they claim qualified immunity and get it? Possibly. And then you get sort of into the facts of it. But I think, you're going to see some civil litigation connected here. But, I'm going to be totally interested in the child welfare issues because, that's kind of what I do. But with that being said, I have to sign off. Ian, such a pleasure to meet you finally.
Likewise. I just, the only thing I regret is it's like, oh man, I'm coming on looking scruffy, but
you look great.
You look fabulous. You look like you always look, which is fabulous.
I think you look great.
Yeah,
And,
you look great.
And it's, so, because this is the first time I've met Ian, even though we've sort of gone back and forth at times on X, and Bob, I thank you and Ali again. This was, really different for me. I haven't really done it very often. And as I said, I really liked the forum. The people in the chat have been great. And I really appreciate that. So,
well, we were the beneficiaries of you. So we are incredibly thankful and grateful that you elected to hang with us for 4 days. It's been wonderful. As I said many times already, I cherished every second of it. And just know this, you have an open door. Anytime you want to come over here and hang out, you just text me and you're on.
Yeah, Ian's done that too, which I really appreciate. I will tell you, my stepdaughter, who kind of is interested in law, although she's in the big pharma industry, but she watches Law Tubes. And so when I was saying, I might go on after the Karen Reed about some things. I mean, she gave me, like three law tubers that she thought, were good. And they were Lawyer, Defense Diaries, and Ian. And she was just like, it was really funny. She's like, you have to check out Ian. And, these are the ones that you should go on. And so I try, so I had to trust her because I knew nothing about law tubers. I mean, I was
I'll tell you, for you being new to this kind of setup and format and kind of being live streamed, you knocked it out of the park, Judd. So I'll tell you that.
Thanks.
I also have a question, if I can sneak it in before you run. Here in Canada, we've got something called the rule in Brown and Dunn, and the way that works is that if you want to use something in your closing, or you want to argue something, an alternative version of facts from what a witness has said, you're required to present it to the witness. And if you fail to do that, you can get a very strong adverse inference.
Wow.
So the closing that the prosecution made here, the judge would have just been like, I'm not hearing this. This is because, for instance, the thing about, he never said you didn't rack the gun, and he never challenged her on that version.
Yep.
And so here there's an evidentiary obligation that you challenge.
Yeah,
and I was watching that and I was going, what?
Yeah, very different, and really very interesting. What you can't do is, as I think I said earlier, is all of a sudden raise a different theory, like there was a third party that might have been involved or something like that in closing, because then the judge is going to call you up to the bench and say, "Hey, knock it off." You can't do that. But I love that, Ian. That's so interesting. And what's the name of it? Because I want to look it up.
Brown and Dunn, and it's BROWNE.
Okay.
And then DUNN. And it sometimes it gets applied a little too harshly in my view, but it is still like, if I want to say that, for instance, that the witness is, lying because they have some, let's say the prosecution witness gets up and I want to suggest that they're lying because, this other witness has a different version. I have to actually present that version of things to the witness and give them a chance to explain it. So if the other witness says, no, Bob dropped not this Bob, different Bob. I use Bob a lot in my
Hypothetical
examples.
Bob.
Hypothetical Bob, Bob gets up on the stand and says, Frank had the gun. And then I'm going to call Frank, and Frank is going to say, no, Bob had the gun. He just dropped it and sort of threw it over near me just before the cops got there. When Bob gets up to testify, if my version is I want Frank's version to be believed, I have to actually go, isn't it the case that you had the gun and you threw it over near Frank so that the police would think,
wow.
And he can say no or yes or whatever, but I have to actually give him the opportunity to respond to it. Because, and it's exactly intended to prevent the prosecution close in this case where they're like, she was inconsistent on this point. And it's like, but you never actually crossed her on that point.
Right.
Yeah.
Oh, I agree. Very interesting. And
that's fascinating.
And I saw your posts on X, kind of about that and in your view of it. And I thought they were great. So, so I'll check it out. And I hope I'll see you again. And
likewise,
hopefully we'll hook up again on another case. And Bob and Ali, again, thank you so much. It was
truly
really
our pleasure.
great. So, all right, guys, take care. Wonderful.
Thanks, Judge.
You.
Thank you. So big day there, Ian, huh?
Yeah, I will admit, I came down, I was like, I am 80% certain that this is going to be an acquittal. And the judge does the thing judges always do, which is, I'm going to give the verdict and I'm going to leave you on the edge the entire time until I give the final.
Yeah.
And I've resolved that if I'm ever a judge, I'm going to come in and it'll just be, my verdict is acquittal. And now I'm going to explain why.
Tell you why. Yeah. It's, because we're always stuck there as lawyers trying to read the tea leaves, and at some point, I'd say about 30 seconds in, I was getting the vibe. As soon as he started basically, championing the police and what a tough job it is, and it's thankless and it's dangerous, and these guys are good people.
I knew. Nervous.
Yeah, I knew it. I knew it at that point. He was going to go NG, but yeah, I felt the same way. And in my, I had felt going into it before Bradel had let it be known that they were going to go bench and that Kelsey was going to waive. I thought, based on the last couple of hearings that I had watched with Judge Karp, that was the way to go, because to me, this case just lived in a firm understanding of what beyond a reasonable doubt is. And for me, I wouldn't be willing to risk it with a jury, because it's just tough.
This is one of these questions I'd love to be able to ask Bradel, and he will probably never be able to actually answer, because it goes to like their deliberations and discussions with the client and all of that. But just the issue of, one of the concerns I would have with a jury, and it's one thing to say this was a great decision in hindsight because we already know the outcome.
Yep.
But I worry that the jury would go, okay, do I believe Noonan or do I believe Fitzsimmons? And the problem with that, when you get to like, which one do I think is more credible, is you've taken the standard from beyond a reasonable doubt, and you've just by mental accident changed it to balance of probabilities, right? Yeah. And that can never be how this works. In Canada, the jury instructions actually sort of follow a bit of a formula on that. It's the rule in W&D. And so if you search W&D and you look at like citing cases, it's like 100,000, right? It's like everything cites this, because it's the it's the question of when you've got like a credibility contest.
Yeah.
And So the sort of formula or the step process that they advise people to take is, one, if you believe the accused and the accused evidence acquits them, and they actually had to add that because there was a lawyer who tried to do something really clever. It used to just be, if you believe the accused, then you must acquit. And then they had a lawyer who got the accused up on the stand to admit the crime. And the lawyer was like, if you believe the accused, you must acquit. And the judge is like, no, the formula has to be, we're going to add a little phrase to it. If you believe the accused and the accused's evidence would acquit them, then you must acquit. So, I mean, it's one of those too clever by far moves by a defense lawyer. But,
Yeah.
And so for that, you'd have, and I mean, here we would see things, you know, where a judge might say, having reviewed all of the evidence, I found the accused evidence to be credible.
Yeah.
And this ends the inquiry. I do not need to continue the inquiry as to whether I found any other witness to be credible.
Right.
They might do that. But if you don't believe the accused, you still have to ask if the if the accused evidence can still leaves reasonable doubt.
Yeah.
Because I had a case, it was a fraud case, and my argument was basically, my client's a bit of an idiot. She doesn't know what she's doing, and she didn't mean to defraud anybody. She just couldn't navigate the bureaucracy and failed to navigate the bureaucracy in a way that happened to benefit her. But we don't bring in all the people who fail to navigate the bureaucracy in ways that hurt them. So, right. And the judge basically came out and said, I do not believe a word that came out of the accused's mouth. But this bureaucracy had such poor paperwork and such poor bookkeeping and such poor handling of its things that I cannot say beyond a reasonable doubt that it couldn't have happened that way.
Right.
So even though I don't find them credible in the slightest, I still have reasonable doubt. And so walks that way. And then the final step is, if based on the evidence that you do accept, can you convict beyond a reasonable doubt? Because you can also get cases. I mean, I had a case where my client got up and he was such a terrible witness. Awful. And I put him up on the stand. His evidence was awful. And I was just like, okay. And the prosecution in their opening is like, or in their close is like, you cannot believe this guy. His testimony was not consistent from one statement to the next. His testimony was all over the place. And I get up and the judge is looking at me like, well, and I said, you know what? I agree. I'm not going to ask you to put any weight on my client's testimony.
Yeah.
I'm not going to suggest to you that it's credible. And the judge sort of goes, huh? Like this, where's this going? This is not the direction I was expecting.
Unique.
Said, but the problem is that this case is fraught with that. And I'm also going to suggest you can't put much weight of, if any, on the people accusing him.
Right.
And at the end of it, the judge, his ruling was, I don't believe the accused. I don't believe the other witnesses. I don't know what happened because I don't think anybody came in and told the whole truth or even the substantial majority of the truth. And so therefore I have to acquit because I don't know what happened. So, pointing out to people that you have the possibility of nobody is credible. And this is the problem, is I don't know that a jury would recognize that either, that they don't have to, they can believe everybody. They can believe nobody. They can, all of these things. And so it ends up converting it to balance of probabilities, which is extremely dangerous. I see somebody saying Mrs. Runkle must be home. That was Bob's dog.
That was Nanook. That was my guy. That was my guy. Somebody rang the doorbell. So, he got all excited.
My dogs are being good. They're being quiet.
Yeah, we've had several mornings with our pup. He's been down there barking at Ali's feet while we were on the live. He was like, I'm ready for a walk. I'm ready for a walk. Yeah, no, that's, and I appreciate that they at least try to address that, because that was an interesting thing. And I agreed with you when you first came on in terms of that. That's how I was looking at it as well. I found, unlike a lot of the chat, I found Noonan to be somewhat credible. And I thought that Kelsey was absolutely credible. So I was kind of challenged with this thing where I've got two witnesses who, and again, I talked about the potential of maybe putting on some kind of witness that could, instruct the judge about our memories and how, false memories are created and things of that nature. Because it's just hard to know, because what somebody may think is true, to them is true, even though it's not an accurate memory of what actually occurred. So
I did not find Noonan credible.
Yeah, see, I found him kind of credible, but I didn't think about the aspect of that there would have been the cartridge on the floor had he racked it again. That's
the other
big, man.
So the other problem with Noonan is his
Allie's
time
going to
frame
make you
doesn't
go
work.
through the whole thing.
Because the judge just called my case, so I have missed everything that started with you answering this question.
Fair. So is there a way the round could have ended up in the chamber without it being racked?
Right
So in order to actually, do you guys mind if I hold up a transparent airsoft?
No, you're allowed. You get away with that on your channel, right?
Yeah.
Yeah,
it's
that's
just
fine.
you never know what YouTube's going
I
to do.
actually saw you because I was
this is
trying to
super
watch.
transparent, right?
Yeah, I was trying to watch one of yours because everyone was said that you did a really good thing about the tap and rack. So I went back to watch, and then I fell asleep. But I had seen I had seen some of it. So
this is your magazine where your cartridges would live if this wasn't an airsoft thing, right?
Okay.
And so the way it works is the slide actually has a piece in it that will take a cartridge and peel it off the magazine, and then it gets guided by the feed ramps and into the actual, on an actual like real thing, you'd have an opening here for ejection.
Mhm.
But you've got your chamber, and it actually guides it into the chamber. So in order to get it into the chamber, you have to open the slide. Now, there's two ways you can get a cartridge into the chamber. One is you've got, magazine inserted, and it pushes it in by the automatic operation of the thing, right? But let's imagine you forgot your magazine. Or, let's imagine you're an officer, you're in, some sort of firefight. You accidentally hit the wrong button, your magazine drops out, and it falls into a puddle or like into a storm drain or something. And you happen to, for some reason, have loose rounds in your pocket, but you don't actually have another magazine.
Right.
And so you're like, I really need to shoot the bad guy, but I don't have a magazine. Well, it's not going to automatically be able to cycle rounds in, but you would still be able to fire one at a time by opening the thing, and you'd actually have a slide lock that you could lock it open, inserting something by hand, and then closing it. But you notice in both cases, the slide moves.
Slides
right?
operation. Right.
Because when the gun is what's called in battery, which is the slide is closed and everything is pressed up, there is actually the breech face is holding the cartridge in such that it can't move, right? And you can't pull the empty casing out. You couldn't put a new one in. It's a closed system.
Right.
So the slide has to move in some capacity for that to happen. But the thing is, his first story, the one he tells on direct, is that she has the malfunction and she goes tap, rack. And if, so tap, rack, right? The first tap, rack, assuming she doesn't pull the trigger, there should, at that point, after the first tap, rack, be a cartridge in the chamber. And then the second tap, rack
would eject it.
And
she'd be left again with nothing. Or would there be a new one in there?
There'd be a new one in there because there's
Okay.
a magazine feeding them.
Got it. Right. Forgot.
But there should be one on the floor at that point. And then they have the so then you've got, that version. And then on cross, he seems to start realizing that he's got a problem.
Right.
Which is why he says that she failed to properly, she half does it or she slips or whatever. And the thing is if you half rack it, then you are likely to jam up your
Jamming
gun.
it. Okay. And that makes sense to me.
Now, if she just slips entirely, then it's just not a rack.
But
And
he
so-
said half racked or something. He did say that.
He says half rack on this, like on cross, once his evidence starts being
Like, oops, there's not a round on the ground ejected.
Exactly. So, the question I have is if she's racking it twice, why isn't there a cartridge on the floor somewhere? And why aren't we down 2 cartridges, right? Now, the problem is you've got the 18 plus 1 issue, or the 17 plus 1 issue, because the magazine holds 17.
Mm-hmm.
And the plus 1 is that the gun itself can hold
Holds 1.
So, the expert described, you can put the thing in, chamber around, drop the magazine,
Fill it
put
up.
another round in the magazine, and now you've got
Is that standard
18.
police procedure to do that? That whole
Really
thing?
common. Yeah.
Okay.
Really common that you do that just in terms of, all of that.
Maximizing the right.
So, now because you'd hate to die with like when one more
One
round
bullet.
could have saved you, right?
Right.
So, and this is also people buy extended magazines to have a little bit more capacity, all of those things, right? But, if you assume that it's just 17 rounds and not the plus 1, but you see, it gives us a problem of that. Like when you look at the magazine at the end of it, you've got that problem of variability. The other problem you have is that notwithstanding that this could be, 17 rounds as the maximum.
Doesn't mean you filled it to max.
You can load it with 3.
Right. Plus,
right?
she was just doing some training on Friday, so she may have spent some of them, right?
Oh,
how many were left when they claim that they checked it? They say there's 1 in the chamber and how many in the magazine? Do you remember?
This is the thing is I would have liked the expert to get into this a little more. And I would have, if I'm the prosecutor, I am going on this hugely, right? Because this is my theory. I am just absolutely mining the shit out of this. I would have been like, okay, when you found that cartridge, did it have any primer strike marks? Okay. So it, and I would have asked them to explain what a light strike is. I would have asked them to explain this. I would have asked them to say, okay, and when you tested this firearm later, did it fire? Did it have a light strike? I would have said to them, I want you to take that, that item, and I want you to run 200 rounds through it. And I want you to see, did it ever fail to fire?
Mm-hmm.
Because you can say, some firearms are unreliable. They may not fire regularly. But we ran 200 rounds through it without a stoppage.
Mm-hmm.
It was a really reliable, it's a
Weapon.
Glock. It's really reliable.
Right.
So, at that point, you're starting to close those doors. And I think that if they'd actually put all of the work in, that the prosecution could have had a much stronger case. And I would have, if I'm the prosecution, I'm also going after Kelsey Fitzsimmons on the stand. I'm going at, and he didn't. The prosecutor just kind of was like, I've got this in the bag. I'm done here. It's clear that's where he was at. He's just like, I don't even need to cross her really all that hard. This is all in the bag. And, but some of the stuff Noonan said is just, it plainly didn't happen. You've
Right.
got your item here. The first thing is you pull the trigger. You got to figure out that it didn't fire. That actually takes a moment of processing. Then you got to... That's not, it's not super fast. It's actually going to be harder to do with a real thing rather than this fake one, because this fake one has a really light slide. You can push this back, without a whole lot of effort. Whereas real things tend to have a slide that has a lot more spring to it, because of course they do.
Right.
So, if nothing else, like the spring in it has to be a spring that's designed for a big metal object, like the slide is metal, whereas this one is cheap plastic, right? Cheap plastic is obviously not going to weigh the same as the as the full thing. So you've got all of these issues there as to, what he is describing as her motions.
In the closing now, or are you talking still about Noonan?
Noonan.
Okay.
What he describes her doing would be a very challenging set of maneuvers for somebody who is very
new,
well trained and well practiced.
Okay.
If I go to a 3-gun match, most people at the 3-gun match would not be able to pull this off. And this is people who practice these and drill on it. You'll get people who are just like, I spent 4 hours for the last, week drilling clearance drills. Tap, rack, bang over and over and over again, 4 hours a day for, a week leading up to a match just to be like, I'm going to be good at it. Right. This is a very challenging set of things. And I mean, there's people out there who could do it faster.
Right.
If we pulled up and don't, because YouTube is, a problem, but if we pulled up Jerry Michalek, who has a world record firing 10 shots out of a revolver at targets. And he is so fast that you can barely see him move.
Wow.
Like,
that's how you are? You're almost like that? You're
oh
that
God,
good?
no. If I could be like 1/4 as fast as Jerry Michalek by the time I die,
okay,
I will have done very, very well at training. But I just
you're just saying that basically a new cop who has not been like specifically trained or been doing that is not going to be able to do those maneuvers.
Yeah. And think about it this way. If I give you a Rubik's Cube and I tell you to solve the Rubik's Cube, right? You might be able to go and start solving the Rubik's Cube. I don't know if you've ever played with one or not,
of course,
if you got.
And then there's some people I hand it to and they can do all the colors, solve the whole thing. I can do like one, maybe two. Right.
And the thing is if I also told you to do that and to walk backwards, solve the Rubik's Cube and walk backwards,
right,
you would have a very difficult time solving the Rubik's Cube and walking backwards at the same time, right? You're doing two different tasks that require some thinking, some operation. If you practice the tap rack enough, it can become an automatic thing, right? There's people who can solve a Rubik's Cube while, blindfolded and riding a unicycle. There's people, and that's because they've solved the Rubik's Cube so many times that it just doesn't take any mental processing at all. But for the average person, it still takes some mental, stuff.
Acuity.
And so the aspect of, moving backwards and so forth. And I see DB saying, tap racking is the simplest way to clear a malfunction. Yeah, you're not wrong. It still takes mental processing. If you watch 3-gun matches, the people who are not in the top 30 at your local match, the people who are just the ordinary practice shooters, when they're doing a tap rack bang, they stop running. And they stop running because they're doing one thing at a time.
So what the prosecutor described in closing, the way he claimed that the testimony came out, do you agree that was inconsistent with what Noonan testified to?
The thing is I think the prosecutor may have been right. And the prosecutor may have had a path to conviction, but did not properly explore it. Because there are issues with how the firearm functions that we just don't know, because they weren't explored, they weren't dealt with, they weren't ever addressed. But if I'm the prosecutor, I am talking to my expert, I am absolutely making sure that those firearm issues are pinned down.
Yeah, and it's like he didn't even establish to the judge that the only way to get the round in the chamber is to do something with the slide. He didn't actually like prove that, and that he's just expecting people to get it because. And I'm just going to play this one part real quick, and I'm sure I know that everybody heard it, but this is where I was like, is the judge right on the law but wrong on the mechanism of oops, wait, I did the wrong thing of the of how the gun works, but right because the prosecutor didn't actually prove that. So this is what he said just on this one little issue.
To be true because there was a bullet in the chamber, and she said that Officer Noonan shot her without ever having racked.
Let me go back. I had the volume down.
Commonwealth argued that it is scientifically and physically impossible for Ms. Fitzsimmons' story to be true because there was a bullet in the chamber, and she said that Officer Noonan shot her without her ever racking the slide after pulling the trigger. I disagree that the evidence reflected that the only way to chamber around would have been to pull the slide under those circumstances. However, even if I assume that...
So that statement by the judge is that technically, as far as, was I playing it?
They needed, yes. The video wasn't shown, but we heard the audio.
Oh, Jesus. Sorry.
The thing is that one of the things I find tremendously useful when I'm preparing for a gun file is Mrs. Runkle, who knows very little about guns. And the sad thing is that Mrs. Runkle is learning more about guns, and then I have to go to other people.
Right.
But it's really useful to have a friend who is just completely clueless about firearms. Because I want to, and then I can be like, okay, let me run through my planned evidence. And you'll get a question that to me is just a really simple question. They'll say something like, well, is it possible to fire the gun without racking the slide? And it's like, okay, I needed to explain that. And the reason why it might not have been explained is because it's one of those things that you just kind of assume people know. And so you have to, because firearm expertise ranges so dramatically, you have to kind of take a position that would be insulting to a firearm knowledgeable person and explain every single detail.
Right.
And I mean, I had a case where the judge said, Mr. Runkle, my father was an armorer. And I said, Your Honor, then assume I'm talking to the transcript right now.
Right.
And
exactly.
The judge is like, I understand, Mr. Runkle. There we, continue.
Very good answer.
But it was just, but sometimes I have had judges say things like, is it possible that the firearm could have fired without making a noise? And I'm like, the gun makes big bang, right? Like, those things are, so
I guess it's fair to say that the state didn't put on the evidence that proved that fact. So that's why the judge can say, I can say that that I disagree that the evidence says that the only way the round could have gotten in there is to move the slide. But what it sounds like you're saying is the only way the chamber could get in there is to move the slide.
Yes, but the problem is there's other ways that could have, like that state could have occurred.
All right.
And it's just, this was not explored.
Okay.
I thought the prosecution didn't do a great job with their firearms expert. And there were absolutely lines of, argument that I would have gone with the prosecutor. Because I would have gone with, okay, we see in that gun box, that gun has a Spartan logo. It's got a Molin Labe on it. You got a few guns in there. You've got some gun practice, don't you? Like, I would have gone into that, right? That was something, and the prosecutor doesn't touch it. I would have been all in going like, because Noonan's theory of things really requires her to have a certain level of proficiency. And I don't know if she's proficient. It could be she's actually John Wick.
Right.
But we need the evidence on that. I would have gone and been like, you know, if I'm the prosecutor, I'm going, can we find any evidence if she's ever competed?
Right. I think
has she ever posted a
has she ever-
competition video?
Right.
You know, because maybe there's a competition video showing her doing exactly this. At which point you're like, Judge, this is exactly what it looks like.
Right. So I think that no matter what they would have done, given how Kelsey testified and how credible he found her, that all of the shortcomings in the the mechanism of the firearm, I don't think it would have changed his opinion that he believed her, that she did not point that gun at him. And even if he decided that at some point she racked it and forgot, or at some, you know what I mean, but that he believed her when she said she never intended and never thought she pointed that gun at him. And that's where it lived and died.
And that's the thing, is ultimately, if you want to, if you want to actually argue some of these things, you've got to bring the evidence.
Right.
And that, I think that the judge basically said, here's where the evidence was missing. You didn't have evidence on the firearm operation to the degree that needed to be done. And you didn't have body camera footage.
Right.
Body cams would have been amazing, because body cams just settle the issue.
Right.
You know, because Kelsey's version of things is that Noonan turns around, goes down the stairs. I find it plausible because Noonan trusts her. He isn't expecting her to pull some sort of shit.
Right.
So, he trusts her. Maybe he goes and looks at something else for a second. And if we have that on body cam, we would see the camera turn, go down some stairs,
Right.
and then come back up, and then, turn and, go, oh my God, Kelsey's got a gun to her head, right? We would see that on the body cam. Or we would see the, or we'd see
where the weapon was pointing.
Ninja dive and I mean, I would have loved to see that body camera footage, because that would be impressive as fuck based on what, we just see Kelsey being a complete badass.
And I think that if Kelsey's story wasn't true, that she would have adapted her story to more closely fit their story. Like, she could have changed her story around, which is why I'm like, well, it screams to me that she's telling the absolute truth, which leaves the only possibility that they staged that gun after the fact. I mean, it does sound like you're saying there is some other set of circumstances that could occurred where the gun ended up in that condition. So maybe nobody had to tamper with it. But it's
Runkle, we have important intel, which we knew because we had your live on from the other night. You're in search of the Sue's aperitif. And I am going to see to it that I have a bottle in hand when you arrive in Chicago.
But he specifically said for not everyone to bring it, because he can only bring so many bottles.
That's at the meetup.
Okay.
He
can drink. He can drink your bottle.
This is friend to friend.
I can bring one bottle back. And so the thing is it's like, if you guys have got the bottle, great. The concern I had is I mentioned, hey, I'm looking for this, and there'd be like 4 people, and I'd be like, I have to drink this in the next day.
Yeah, you're gonna have to really, really tie one on. So nobody has to worry about that. I got Runkle covered on that account. The whole thing with the gun is fascinating, though. It's like that aspect of it was, because that was interesting. Right, Ali, in terms of there being another way aside from nefariousness by the cops that a round could be chambered.
Well, even just ordinary carelessness by the cops could do it. So, for example, if you're sitting there, you find this on the bed, right? And you just go to clear it. And so you go and you check, no round in it. whatever, but you forgot to pull the mag. Now it's chambered.
Now there's a round in it.
This is a way people actually get killed by accident.
Yeah.
And when you've got multiple cops in the room, all of whom are reacting, you could have one go and check the chamber just to be like, why didn't this fire? And then sets it back down. And then later the officer comes in and does the proper full unload and goes, all right, this is the round that came out. You know, this is the kind of stuff that could happen accidentally by sloppiness and that you would never discover, except if you had body camera footage, which would actually allow you to see, oh yeah, this officer checked the gun. And that's when it got chambered, right?
Yeah, apparently they got funding for it like a bit ago. Like I think somebody messaged me that
It
they had
takes a
funding.
while for that to happen, but I mean,
It's a good thing they didn't need it. Save the money for child custody.
But I've got
No,
to
they need it.
I gotta run and get back to work. So
Well, we love you,
I will,
Runkle.
Thanks,
for jumping
Ian.
on.
Likewise. And I will shoot you a message. I will likely be looking to be like, hey, assuming you guys aren't like super far from the courthouse, because
I mean, it's like
Well,
it's
we're not
like,
great.
We're like 45 minutes, man.
Which, the federal courthouse? Or
No, he's going to Washington Street.
Okay.
So
I don't know which one it is, but it's
The Daily Center.
I know it. No,
yeah,
it's
No,
not
Dirksen? All right.
No.
forget it. Okay.
it's not the criminal one. It's the
on
civil
Washington.
downtown. Yeah.
Well, if it's a civil downtown one, then it might be the Daily. I know you have one thing up that's in the like the building on Washington where they handle. So
Yeah,
but
I
we'll
gotta
talk about that.
I
off
gotta
air.
check. We'll figure it out. And
Yeah.
I mean, worst case, I might need to just hit you guys up for a ride because yeah,
We got you. I mean, if you decide to stay with us, I'll just drive you down anyway. Because
that works.
Yeah.
So
All right, cool.
all
Hit
right,
me up.
thank you guys for having me on. And
Always.
yeah,
Thanks for
You
coming.
much like the judge, always have an open door. Over
Always appreciated.
awesome. Well, thank you so much and cheers.
Bye, guys.
Yeah, thanks.
That was great getting
It was
Runkle on.
great.
I'm
loved it.
still.
He jumped in chat, and then I immediately sent him.
Yeah, we
an
all
invite.
saw that.
I didn't know if he was home though. You know, he could have been out runkling. You know,
Yep.
doing runkle things.
Dawn was like, I didn't want to be on the wheel, so I saved my super till now. Thank you. Rachel,
fair.
Queen. I'm going to say Queen, but that's like QN5EO. Welcome, became a member.
Oh, I'm sorry I dipped, and I'm going to give a little personal intel. Cam got a tick bite, so she was freaking out.
What? Like a
Yeah.
tick is on her?
No, the tick has been removed, but she said she didn't find it till like 4 a.m.
Who removed it?
Cameron.
She removed her own tick.
She took her own tick off. So of course she's paranoid about Lyme disease. So I'm like, we'll keep an eye on it. I did the Google
How'd she?
searches.
All right. I mean, there's
Well,
like
she was at Star
there's certain
Rockets.
ways to get it off, and like the
I mean, maybe it wasn't dug in. Like typically you got to put a hot, like, you know, light a match, put the exhaust the match.
Did
and
she
put
save the
hot
tick?
stuff. I doubt it.
Oh, that's how. So we can see.
I
if
can't
it-
even believe she took it off with her like horrific fear of insects, all
I
bugs.
know. I know.
I mean, the chick sees a ladybug and she's like losing her mind. I'm like, it's a ladybug.
Paige Soap, all three of you. Rachel, Paige Soap, welcome.
Oh,
Family hugs.
Family hugs. Yeah,
Yeah.
I'll do the family hugs. Like
Okay.
no one likes your family hugs. They're not authentic.
I think we might have read this one already, but I'm not sure. What is it? What did we say? That's Joey Perry. I think the moral part of the closing was trying to make the judge believe Kelsey is more credible, honest than the other side, which I believe she is.
I thought, and then somebody else had an interesting comment as well.
I think it was the judge that it was tying to the moral certainty that that one.
Maybe it was you that said it, or is that the
The
yeah,
judge.
that was
That
the
was
comment. Yeah.
Judge Carol Erskine said that.
Oh, she said that. Okay. Yeah. I thought that was astute. Per usual.
Yeah. Runs with.
Oh, wait. Somebody says that your family hugs are good, babe.
Oh,
I
thank
take it
you.
back. I
Some
take it
people
back.
just, it's like my oldest daughter. With her, I can do no wrong.
See, you guys might not know the backstory. Allison was like, when I was first giving family hugs, she's like,
That's
you need to quit doing that.
lame and weird.
And
Yeah.
I'm like, it's not lame, it's not weird, it's loving. And you know, I
It's
like to
true.
show-
So it took me a really long time before I'd get on board. And I was like, save you that family hug for when Bob's back, because that thing I don't do.
yeah. Yeah, I love to give the family hugs. I like whenever we run into people in real life, I give real life family hugs too. So be warned, because I know some people out there are not fans of hugging.
Then
And
just
don't like to be
take a
tough.
step back and put your arms
I
down.
always ask first, though. I always
Runs
ask.
with dogs, and I think we read this one before. You help us become more informed citizens. Thank you, Runs with Dogs. We appreciate that.
We
Michael,
really do.
if the information provided to police by Limpy is proven to be lies, does that open him up to a lawsuit by Kelsey? I mean, he could do a malicious, I mean, like, look, it's nobody wants, I think her lawyers would kind of advise away from like a lawsuit with Limpy. It's like, what's the point? It's wasted money, wasted energy, like save your energy. But
Why am I not seeing the Limpy emojis anytime we mention Limpy in the
I don't
chat?
know.
Come on, y'all.
But if he lied and it was, he has to be using for malicious prosecution or abusive process, be using the process for a reason the process isn't intended, but he was trying to get an order of protection, but didn't want an order of protection, really wanted custody. That might be an avenue to, but I can tell you a lawyer would suggest that she take the win and like, it's better for her soul. Let that go.
Yeah,
We touched on this.
I know what's going to cure the soul is holding her baby. That's going to really, she's going to feel like she's back on planet Earth as soon as she gets her hands wrapped around that baby.
Oh boy. So
thank you, Melissa.
You're right. She was obviously not guilty, and the judge agreed. Stacy, new member. Wait, Liz, new member. What do they get?
Aw, family hugs. That's
yes. Aurora Aura. Thank you, family hug. Time.
Aw.
Tim's leg is going crazy. I'm sure it was. I didn't notice that. Oh my Lord. Alpha Sheworth Wolf member 26 months. Hallelujah. Now give her her child back. Thanks for your continued support. We really do have to work on this whole badge thing. You know,
We
like
do. I
people need
agree.
badges.
I agree. This is not a case of we don't need no stinking badges.
Right.
This is a case of we do need stinking badges.
Edward Kirkpatrick says, Judge, drop it in the body cam line. Agreed. I'm a big, you have to either say it or do it, not both. I'm like, no. You don't say.
Yeah, Ali takes
chef's kiss. I'm
great
like, no.
umbrage to people that say, oh, chef's kiss, and then
I'm
do
like,
it.
or you do it and then say, I'm like, you just said it. That was what this was.
I'm trying to remember the exact point in time when you like announced that irritation. Like I can't remember what triggered it, but I remember
First time I saw someone do it.
happening. You're like, what? No. Wait, they said it and then they did it. No, that's not a thing. Yeah.
But a lot of people do, but that's just me. Carrie Cherry says, I don't think it's a conspiracy, but the police failed. Well, the judge agreed. Not having child services involved, not securing guns, letting Justin in, but I don't think the cops see it that way and won't make changes. And that's why there seems to be a lot of people locally and in Massachusetts up in arms about this. So hopefully they really will reach out to their representatives and push for change. Thunder, thank you. He says, thank you for the coverage, Bob and Ali. Ashen Sugar says, now on to probate. Limpy. So she was using the emojis.
Indeed.
Face, watch out.
Indeed.
Disc World Edge Witch. I made the mistake of putting makeup on while waiting for the verdict because I need to redo it now. So she's crying. I mean,
that's
yes,
sweet. It was a great
sweet.
moment. It was a great moment.
Thanks
Truly.
again, Rachel, for your super, very generous. Thanks for
Rachel.
all of your generosity. Kelsey, the forensic nurse. I won the 15 minutes, but never got an invite. Oh, Kelsey, what are we supposed to do now? It's 3:00. I'm sure she doesn't want to come on now.
Kelsey, you have a standing invite. Come on.
But but we need to get her email to send her the.
Yeah, did you send the email,
Oh,
Kelsey? Because we needed you to send the email because otherwise we don't know where to email it to.
I mean, you're more than welcome. If you're still in the chat, we will keep this going at least another
Come on
15
down.
minutes.
Or you could switch it to any other live that we do. It's completely up to you.
But if you want to talk about this and you're ready to talk about this, and
Bring
know,
it.
we just you can either email us or put it right in chat. Trace, are you paying attention? Let's see. To a true
There it is.
crime.
Here, I'm going to put it up there. So that's where you a true crime pod at gmail.com.
You send us your email, we email you the link.
Indeed.
I'm going to look at regular chat to see. All right, Tracy's paying attention, so that's good. And I'm just seeing if she has said anything else. Always doubting me, Tracy says. I don't know if she's talking to us or someone else. Never, we never doubt you. I don't know what.
We never doubt
Don't
you.
put your email in chat. Everyone's saying, okay, yes, email it to our email. All right, somebody pay attention while I continue on with this. Now I feel awful. She's been ready.
I know.
She's ready.
She's been ready. She's been on these streets.
Oh boy.
Probably got all gussied up. Got her hair did. Ready. Walk on the stream.
All right. So Biz for Bob, new member.
Oh, love it. Aw, family hug, Biz for Bob.
Donnie, not Wahlberg, the panel of all-stars.
Indeed. We had a great panel.
I know Runkle pays
jumped
attention
in.
to the chat. I'm sure he saw it. Oh my goodness. A.G.
Whoa.
Curly.
Wow.
What do you think?
You'd think what
we
I
would know
think,
after 28 months.
What I don't know what this wee shit is.
Do you know?
I mean, it's clearly A.G. Kearley.
And you say, I don't know what this wee shit is, but thank you so much for your continued support. We got to figure out who's the oldest, because I don't know if I've
That
seen
might
28
be
months.
AG might be the OG.
The
Like
OG,
the
OG.
Like Sober Hister's been here for a long, like
I
we've
gotta
got
remember.
some serious OGs. Spitfire's been here for a damn long time. What are you at, Spit?
I think she was saying
24?
she's ready for her 24. I think this was her 24th month.
Yeah,
She
we
was
gotta-
asking for her badge.
We're
But
gonna-
great
we're gonna
day
make
for
it right.
Justice, Judge Erskine's fangirl. Oh, that's sweet.
Yeah, she's
Thank you for your continued support. We really appreciate that. Slam RN. I just got into this case a couple days ago. Where is the best place to learn about what happened in this case regarding the judges, etc.? I felt lost. I would say, like, wall-to-wall coverage, front to back, like from the attorney Melanie Little.
Yeah.
So she's got a YouTube channel. She is also a lawyer, and she covered from the first filing to the last filing. I know that we did something right before trial that could be a little bit of a foundation, but yeah, I would definitely check out Melanie's.
I mean, we covered the hellacious hearing with the judge, with the, we did that. But in terms of front to back coverage, Melanie's definitely been on it the whole way.
From the jump.
Yep.
They dot, as they say on the other side of the pond.
And thank you,
They
Slam.
dot.
We
Thank you,
appreciate the
Slam.
generosity.
Jaded for Justice says, I was half listening a second. I tried to put that up when Ian was on, that Brown and Dunn thing, and it's DUNN. I thought
Like
Ian
shit and
said,
get off. You forgot, like shit and get off the pod.
Right.
Brown and Dunn, like shit and get off the pod. Did you think that's how Canadians said I'm
Shit and
going
get
to
off the
take a
pot.
dump?
Dropping the
it was
kids off at the
Brown
pool.
and Dunn.
No, Brown and Dunn.
Brown and Dunn.
Like, yeah, Brown, and now I'm done.
Yeah, the old Brown and Dunn. Right. I'm with you. I'm totally with you.
Dump and flush. All
dump
right.
and flush. It's just courteous. It's courteous. The dump and flush.
Yes. Charles Argo. Did they check to see if the round in the chamber was a dud? That's exactly the things that Ian is saying. They didn't do all the stuff. They didn't do all the things.
They didn't do any of the stuff.
Cookie for me, new member. Oh, what'd she get?
Aw, family hug. That's what she gets.
Afton's almost ready for his badge or her badge. Sorry.
Come on.
I know everyone tells me and then I forget. And then thanks for the coverage and amazing guests. Thank you. Jaded for Justice. Again, I resubscribed just to get another family hug. Oh, you're
Aw,
going to have one.
family hug.
Yes.
I love to give them.
Laura needs a badge. Member for
Indeed.
24 months. Wow. All these OGs. I'm so glad
Jeez.
Thank you
All
for your
those.
continued support. Enjoyed this week's shows tremendously. Thank you. Oh,
And you
idiot
know why?
wins.
You know why the badges are important?
So they know they're important.
Well, yeah, but beyond that, because it's important.
Tracy, you should have a link. I mean, Kelsey, you should have a link. Go on.
It's important for me and us to know who's been with us since the beginning. You know, because when you start a channel, you have small crowds and then you grow. And it's important. You always got to remember where you came from.
I think it needs to be like an OG kind of gangsta.
Oh, hell
kinda,
yeah. It's going to be something dope.
Yeah.
I'm gonna come up with something cool.
Okay.
It'll be something cool. Like maybe I'll have like one of those like big, like kind of
a necklace,
like chain link chains that's got like a big OG, like in gold with diamond encrusted, like it's some gangster shit.
Is that and then we can see that with our eyes, all that or not?
Hell
Really?
yeah.
All right. Idiot Win gifted 20 Defense Diary memberships.
Whoa.
Very generous. Thank you so much.
We love you, Idiot Win.
Yes, we do. MBW member for 11 months. Thanks for the continued support. First, Ali Family Hug. Aw, family hug.
Yay.
Colin Gray. Oh, I was so proud. So he's saying like that's when I first gave out a family hug.
Oh, you were doling out family hugs, and it was your first trial because I dipped to Corey Richens, and Ali like took the rest of the trial. We were actually streaming 2 trials at the same time on our channel. It was a first for us, so it was.
Well, Jennifer was like, "You say 28 months, do you?"
I'm gonna.
I'll show you 29. Hi guys, so happy for Kelsey. We are as well, and thank you for your continued support and your generosity. And the Orlando Sober Hipster gifted a Defense Diaries membership. Thank you for your generosity.
And Sober's a long timer too.
Yes, Music to My Soul, one of my favorite screen names because that is music feeds my soul. So yes, I'm with you on that name. So emotional about the verdict. Would you all consider finding a Massachusetts family law attorney to interview about what this means for Kelsey's custody case? We just had a family law judge on the panel.
Yeah. Yeah. I mean, frankly, I'm sure we could lure her back in and get her to talk about it because it's near and dear to her heart. So
yeah, maybe we do that in advance of what's on March 4th or on March 4th. I don't know.
I mean,
April
just tell
4th,
you
that's when they're in court.
There's a couple of things that are going to have to be addressed. Obviously, I'm assuming, is the order of protection still out there, or was that
no? Wait. They said, I don't know. I thought that the only thing that was keeping her from her child technically was the
scout hug.
Was the bail. I don't know. Watch and chat because somebody will tell us. But I thought the judge was like that there wasn't a no contact. Oh,
yeah.
There's nothing that prevents her from having.
You look at me when you first see me. She looks right at the camera. She doesn't even it's like I'm not even here. She just steps in. She's like checking her look. Give me a hug. That was cool. Oh, sorry.
AirPod.
Oh, her AirPods.
Can I go to Kenna's?
Yes.
Or like she's gonna get her nails done. Or wait, I just made it.
Yes.
All right, we're wrapping up. So let us.
Speaking of which, I'm supposed to remind you about the birthday gift thing. You wanted to thank her.
I know, but not right now. Now.
Oh, okay.
What?
Yeah. Okay.
Nothing. Don't worry about it.
So they got me a birthday gift, and not you guys.
Wow.
No.
How dare you try to put that together like that? All right, go. Bye. Have fun.
All right.
Right before practice.
Okay.
Yes,
bye, love.
6.
That's it. I'm taking you guys off. No, just kidding. All right. You're back. Wow. Kasha Rose. Gonna need my 3-year badge soon. I'm working on it.
Just manhandling me like that. Man.
Another 28 months. Yeah. You got some work to do.
Oh, we got some work.
Julia, member for 14 months. And thanks, Kasha, for your longtime OG continued support. And thank you,
and
Julia,
modding for all that.
And modding. Yes. Julia, for your continued support. And she'd love a family hug.
Aw. Family hug.
Aw, family hug.
Love it. We love it.
See, I did it.
You did do it. I'm proud
Iceman cometh. I don't need a badge because I only have a few months in. LOL.
I'll tell you what, though, Iceman, your few months seems like 2 years.
Yeah, it
because
really
you're
does.
you're a ride or die, bro. So
Yep.
just
And
know
Simply
that.
Bell, 23 months, also in need of a badge any minute now. Thank
Aw.
you for your continued
And
support.
another family hug. Yeah.
Yes. I don't know if Kelsey is coming because we screwed her, but
She's angry.
she sent her email, so I'm assuming that means.
Did we send her the invite?
Oh gosh, please tell me someone sent her the invite. I thought it
Hold
said,
on.
yeah, invite was sent.
Oh, okay.
Yeah, Tracy said. Yes,
Dude.
link was sent to Kelsey.
All right. All right.
But
wait, there's a conference on 25. What's that mean? Like another presser? Let me see what's up. Let me
got
see.
this. Is this it? Go live.
What? No. Is that 25?
I don't know. It's
No,
whatever
because we watched the presser. No, there was one on an hour ago, which we watched.
Trial Lover member for 21 months. Thanks for your continued support. I'll be looking for that badge soon too. Thanks, guys.
Oh boy. Oh
So
boy.
what are we saying this thing is on? The presser.
Well, unless it's a separate presser, we've already watched it, and I'm on Boston 25. I don't see anything.
Oh,
Like
is that what we're? Oh no, we've got. Okay.
Yeah, I mean, I think it's the same thing. It looks like it's the very same thing to me. I'll go home, see if there's anything going
Yeah,
on.
that is, and I'm surprised that did the state never come out and say anything.
Huh? What?
The state never came out and said anything.
Yeah, sure. What are they going to say? Oh, music to my soul is about to get a big giant family hug. You know. Yeah, I think we'll do Delphi tomorrow night. These long, like both of us need to read it, and then I think tomorrow, maybe during the day. What do you guys prefer? Do you like evenings? Or do
PB
you
and
like
Shelley says
days?
she did like a membership thing and it didn't get discussed.
Well, here, PB and Shelley. Aw, family hug. What do you mean
Sarah
it didn't get discussed?
Witherow, member for 13 months, just asked that very question. Info on Rick Allen's case?
Wait, PB and Shelley got stiffed? I don't like people getting stiffed.
Well, that's why you just gave her a family hug.
I know, but you whip by it.
And
people need to know.
And music to my soul needs a family hug as well. Welcome.
Aw, family hug.
So on Rick Allen, we want to go through it and like digest it before we just start spitting shit out at you.
Yeah.
And we just haven't had time.
No, we've been busy with this
Has
case.
anyone seen if Kelsey has said anything, or Kelsey, not trial Kelsey, but chat Kelsey, about if she
Our Kelsey.
Yeah, our Kelsey gonna come in.
You sent me the emojis, but you just wait. To you, but just sent it to the email too.
So here's the thing: if we don't get on today with Kelsey, you can come on April 4th when we're covering the custody stuff, and then there'll be some new things to discuss. And
if you want it to be Kelsey, and like I don't want anybody to get, kind of like misconstruing. Like they're not like custody shit is never going to be streamed. Like those, they're not gonna we're not gonna be able to watch those hearings.
Right, but we can. Right, so
nor would I want to. It's such you're really delving into people's private shit. Like when
right, but if there's we can get on to discuss what we end up finding out that happens.
Oh, thanks, Kurt. Kurt's like, great job with the Afro Man lawyer interview. We appreciate that, brother.
Yeah, thanks, Kurt.
Thanks,
yeah,
man.
I saw your post. I was gonna say we could get to the juror that we interviewed if maybe she'd be willing to do an affidavit. Maybe. Lori
Oh.
Jane gifted a membership. Thank you for your generosity, Lori.
Lori
And RK says, long time lurker here. I'd love a family hug from either motto.
Aw. Ready? We'll both give her a family hug. Ready?
Okay. Yeah.
Aw.
Aw, family
Family
hug.
hug. Oh,
Well, we do. We appreciate you very much. Very, very much. You deserve
do.
a hug.
We do.
Sorry, PB and Shell. I'm trying to go back to see where you're, like, what happened to your. Oh, well, look. And we might have missed another.
I don't know what this wee shit is.
Bob's sipping soup like a granny.
You're the one firing through. Like,
I don't know what I
trying
did.
to drag me into your shit. 21 months. OG.
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 We love you, PB and Shell. And then I'm hoping we didn't miss Linda Evelyn's welcome.
Well,
What's
if
she
we
get,
did,
babe?
family hug.
Yeah.
That's big hugs all around. Well,
All right. So I think that's what we should do since we don't see our Kelsey here right now. And I
think she's really salty with you, babe. You know, I'm gonna put it on you, girl.
Yeah,
It was
yeah.
definitely Allie's fault.
Of course.
Kelsey, you've got to make good with us. So, like, whenever you want to come on, you just let us know, and it shall be done.
It shall be done.
It shall be done.
You'd need a new link because the one you have now is dead.
Well, today
Or
was
one
a
we
great
ended.
day for justice. Anytime something goes down the way that I think that it should go down, it makes me really, really happy because it reinstills my faith in the system. And it worked. It worked. You know, they made the right call going the bench. You know, whatever little critiques we might have had mattered not. The judge
Mattered not.
came to the right conclusion on this case. Kelsey got justice today. Kelsey is hopefully going to be having her beautiful little baby in her arms immediately. I'd be filing an emergency motion if I were her immediately. Like forget April 4th. I'd be like, I'm ready now. Thank you very much. That April 4th can kiss my ass. I'm talking now.
Yeah.
Now. My baby needs me. So, but congratulations to Kelsey and Tim and Martha. They did a great job. And, you know, it's what we say over here at Defense Diaries. Gotta love a defense attorney. Gotta love a defense attorney. It's all these little cases where you start to realize, yeah, maybe defense attorneys don't suck so much.
Right. Maybe they're not the scumbags in this.
Maybe they're absolutely critical to our way of life. So, but we love you guys so much. We've had an absolute blast. We've had great crowds in here. We're so fortunate. We love you so much. If you're new to the channel, we hope you enjoyed it. We hope you enjoyed having Judge Erskine on the entire time. That was such a great thing to have access to in terms of her knowledge base. It was fabulous. We loved it so much. If you enjoyed it, please spread the word. And if you're not willing to do that, at least like, share, and subscribe. We love building the channel. We love growing. We love having you all here. We love our chat so much. I think the one thing that you found if you're new to the channel is the thing that I'm always talking about. We do, in fact, have the best chat in the land. I'll put it up against any chat on any channel. We got the best. And I know like people watch all kinds of different channels, but in terms of like the people that are here every single live, you guys are just the best in the business, and it's just a great chat. And I see it all the time. I see the comments from people that are new to our chat. Wow, this is a great chat. It's just a great chat. We're so lucky to have you guys. We love you so much. Mods, thank you for all your hard work for the past, I don't know, it seems like we've been doing trials here for 3 weeks straight. Seriously, like we went from Colin Gray to Corey Richens right into Kelsey, and we loved every second of it. It's a great way to spend our days. We love hanging with you guys. We hopefully educate you a bit. We hopefully make you laugh a bit. We try to bring it all to the table, but we just love you guys so much. So thank you, mods. And to you guys are just the bee's knees. We love you guys more than anything. You guys are the best, because without you, quite literally, I'd just be an old man watching my wife vape. So, like you took a huge drag when I was.
I
right-
know. I didn't know it was coming.
All right, I'm going to do it again because without you guys, I'd just be an old man
Sitting around busting his wife's chops.
love you, babe. Love you guys.
Love you.
See ya.
After